Record, Mr. Clerk.
There's quorum present, Madam President.
Thank you, Mr. Clerk. Do you have any items for the record?
I have no items at this time. Madam President, returning to Legislative Bill 514, Senator Slama would move to withdraw FA 137 and substitute AM 1883.
If there is no objection, so ordered. Senator Slama, you're recognized to open on your amendment.
Good afternoon. Thank you, Madam President, and thank you, everybody, for not objecting to that. What I did there was I simply replaced a placeholder floor amendment to replace with my own voter ID amendment language. I think you'll find, as you consider this amendment, the language is far cleaner and it's far more vetted. I think a point that may have gotten confused on the previous vote on the Evnen amendment is that the Attorney General has not reviewed or signed off on the Evnen amendment. I think that's an important point to flesh out, especially as we're talking about the legal nuances of especially the constitutional problems I see of the Evnen amendment, which was just attached to the Government Committee amendment. So I'd like to dive into the details of my own amendment and invite your consideration and green vote on this. AM 1883 is the white copy amendment replacing the text of the Evnen amendment. As you are aware, the voters of Nebraska passed Initiative 432 to require a photo ID to vote. Nebraskans have spoken decisively, and it is now our responsibility as legislators to ensure that only the votes of eligible voters are counted and to protect public confidence in the integrity and legitimacy of our representative government. This puts us in line with 35 other states in the United States. Just to be clear, AM 1883 is a document that lays out all the provisions of LB 535 and represents months of negotiations between executive branch departments and other various stakeholders in this debate. First and foremost, I understand the importance of ensuring that all eligible voters in Nebraska have access to the necessary identification. It is also important that everyone who has a right to vote can vote. With this said, LB 535 defines the forms of currently existing valid photographic identification, including Nebraska driver's license or state ID card. This is a state ID card issued specifically for voting purposes, which would be issued for free. This also includes a receipt for a state driver's license ID, which the DMV is now required to put photographs on. So remember back in the day how you used to get a paper copy of your ID and it was just simply like a copy of your driver's license along with your pertinent information on it. Now the DMV gives you a copy without your photograph on it. This would just return us to where we were at about 10 years ago, where you get that copy with your photograph on it and it's a valid ID to use. This also includes expired IDs, a US passport, an ID issued by a state agency or political subdivision, including colleges and universities, that complies with the bill's opt-in process. The bill requires these entities to offer this. An ID issued by the United States Department of Defense, the United States Department of Veterans Affairs, the VA, or a Native American Indian tribe or band recognized by the United States government. Nursing home IDs for those on Medicare and Medicaid. Certificate issued by the Secretary of State for those who have no means to get another ID. Additionally, religious exemptions required under case law are also included in this amendment. Even if Nebraskans do not already have these forms of identification, we have worked with the Secretary of State's office to provide a free option for obtaining a photo ID and ensuring that information about these options is widely available to the public, including adding provisions that include the requirement of the Secretary of State to designate an individual to help voters who do not have IDs obtain IDs and help get the necessary documents to obtain the ID. The Secretary of State's office must pay any fees associated with this process to ensure that it is free to voters, including the documentation necessary to obtain a state identification card. Furthermore, LB 535 also lays out the increased responsibilities of the Secretary of State's office, including the new provisions relating to voter identification. This includes various public awareness campaign-related provisions, such as a dedicated website and mailing a postcard to every registered voter who does not have a valid photographic identification. This is crucial to ensure all Nebraskans are made aware of these changes. In addition to what qualifies as a form of valid photo identification and how one may obtain a free photo identification, I will go into the process of how this new requirement will affect the actual process of voting, such as mail-in voting and in-person voting. Moving on to the specifics of in-person voting, which includes the following. The voter must present a valid photographic identification, which is defined in Section 4. There are exceptions for those who have a religious objection to being photographed, as this can be done through a signature verification process. In the event that a voter forgets their identification, they can fill out a provisional ballot and show a form of valid photo identification at the election office within 7 days. As many of you are aware, initially the language included the mail-in voting provisions that required a notary. However, through various rounds of compromise, it has been since reduced to either a notary or a witness attestation requirement. The witness can be any Nebraska registered voter. The notary can be from any state, territory, U.S. consular office, or pursuant to 10 U.S.C. 1044A. That's that previous discussion we had about military IDs. They're military notaries. They're recognized the same in their notary services as notary publics. As far as remedial steps, if the voter fails the witness requirement, they can come in and show an ID up to 7 days after the election. Instructions for the voter and the witness come with the ballot, but are also available on the Secretary of State's website. To address concerns related to citizenship verification, LB 535 assigns the initial and ongoing responsibility to the Secretary of State to verify the lawful status of individuals on the voter registration list. However, it is crucial to emphasize that the Secretary of State can only remove someone from the voter registration list if they ask to be taken off or are convicted of registering to vote while not being a U.S. citizen. The goal of the bill's process is to prevent non-citizens from ending up on the voter list on the first place. And this is a very different approach than the Evnen Amendment, which takes away due process rights and automatically removes somebody from the voter rolls if they're found not to be, from what the Secretary of State believes, a citizen. We eliminate those due process rights under the Evnen Amendment. Mine keeps those in place and follows federal law on that front. In order to ensure voter integrity and the mail-in voting process, LB 535 includes an audit process. The Attorney General is tasked with conducting an audit of witness signatures on a meaningful sample of witness-verified envelopes. This audit serves as a safeguard to verify the authenticity and accuracy of the signatures, reinforcing the trustworthiness and reliability of mail-in voting. This amendment reflects a collaborative effort and compromise between different stakeholders, including the Attorney General's office and the Secretary of State's office. Their expertise and input have been instrumental in shaping a bill that strikes a balance between protecting the integrity of our elections and ensuring accessibility for all eligible voters. The legislation acknowledges the concerns and interests of Nebraskans who have expressed their desire for a photo ID requirement, while taking into account the need to protect access to voting for all eligible citizens. Thank you for your time, and I ask for your green vote on AM 1883. And I would like to quickly address the conversation that's been had about the fiscal note related to this amendment. From what I can tell, and the Secretary of State's office has yet to point me in the direction of any definitive language other than the language that they asked to be included in this amendment, that once they pointed to saying it would be very costly, we took out, pointing out any language in the bill that actually justifies their fiscal note. On this bill, I genuinely believe this is an attempt to have a death by fiscal note for this amendment. I would very much encourage your green vote on this so that we can get an official fiscal note on this amendment and adjust whatever language we need to adjust. This amendment, it goes into what I was discussing all morning. In addressing all of the constitutional issues I see with the Evnen Amendment, I'd really encourage your green vote on this. I think this gives us a far better and far more conservative starting point that we can actually negotiate from. And I would really encourage your green vote on this amendment. If you do vote green on this amendment, I will let this bill go. But I do want to give us every opportunity to avoid a special session. And if we fail to address these constitutional issues with the Evnen Amendment that's now been adopted onto the bill, I will have to go 8 hours. I think everybody on this floor knows that I'm like the last person who wants to do that today. So please, I'd encourage your green vote. It gives us a far better position to negotiate a conservative voter ID bill that actually reflects the framework approved overwhelmingly by Nebraska voters. I'm asking that you stand with me and the voters of the state of Nebraska who overwhelmingly approved voter ID by voting for AM 1883 and approving an amendment that actually requires voter ID. Thank you, Madam President.
Thank you, Senator Slama. Senator Bosselman, you're recognized.
Thank you, Madam President. I caught part of your opening here, Sir Salam, on this, but one question I do have, and you can probably answer it as we come up through discussion on this amendment, is how does the Secretary of State confirm or identify your U.S. citizenship? And could I, Madam President, I'd like to ask Senator Slama a question.
Senator Slama, will you yield?
Yes.
So could you answer that question? How is it that the Secretary of State, what vehicle, what is it that he or she would use to verify the citizenship of every person on the tax roll?
I'm grateful. Thank you very much, Senator Bosselman. I am very grateful you asked that question because it is a key difference between my amendment that's up right now and the Evnen Amendment. So the Evnen Amendment only uses data that's available to the Secretary of State now through the DMV Motor Voter Program. It's a federal program where a person can register to vote when they renew their license. That data is already shared with the Secretary of State's office, covers about 55% of voters registered in Nebraska. The language of the constitutional amendment of qualified voter indicates to me that we need to have a coverage of 100%. So not only are we using the motor voter data in my amendment, we're also requiring that any ID that is allowed to opt into this process be required to share that citizenship language offered, that citizenship information with the Secretary of State's office. So you do have to have 100% compliance. If it does pop up that a person might not be a citizen, they're not lined up, they're notified at least 3 times of you've been pinged that you're not a citizen or you're not eligible to vote. And from there, an investigation is conducted. They are not removed from the voter rolls. It's only after that person fails to cure, that fails to provide evidence that they're a citizen, which we anticipate may happen, and convicted.
My question to you then
Yep.
with that, and that's fine.
Yes, sir.
The question would be is, what are those other forms of ID that you're speaking about? Who controls those, and where is the language? Is there a language in there that says that they can share that information with DMV, and then how does DMV have to protect it?
There is, yes. We do have this very clearly outlined. It's between a few different departments. So like say driver's license information, that'd be the DMV. The DMV's already greenlit, working with us to share the information. DHHS would cover like the Medicare and Medicaid information. Other states who have already done this have used similar language, and it's just simply an opt-in process. The DMV is going to be the one with the overwhelming amount of that data, and it's done through a secure process.
But you said it's an opt-in. So if there's someone who has an ID that's allowed that doesn't opt in, what do we do with that?
It's not an individual opt-in process. The opt-in process I was referencing is like if you're in a higher education institution. Right now we're saying that if you decide to opt in and make your student IDs eligible for a person to be able to vote, you, as opting into that process, must share over that citizenship data so that we can use that citizenship data to verify that you are who you say you are and eligible to vote.
And then if they don't opt in, what's the next, what has to happen?
Then that ID would not be eligible to be used in elections.
Okay, so what's that person supposed to do?
That person can use any other form of the licenses offered, from driver's licenses to even the state ID card that's free for voting.
If they don't have those and can't obtain those, what do we do?
If they don't have those and can't obtain those, they can reach out to the Secretary of State's office. We have language that they are to work with voters in getting those documents, whether it's a driver's license or especially our main focus is those free voter ID cards that are intended only for voting.
Okay, thank you.
Thank you.
So I appreciate the answers. That's a question I have. As I look at the committee amendment and compare that to Senator Slama's amendments that she has, I appreciate that information. Thank you.
Thank you, Senators Bosselman and Slama. Senator Brewer, you're recognized.
Thank you, Mr. President. Okay. I am in opposition to 1883 because what it would do would we replace the committee amendment. understand again that we have worked a very long time in committee to get to where we're at with this. And I understand this is not Senator Salama's amendment, and that is why we're going through this process right now. But we've got 35 other states that have voter ID that we have looked at to try and figure out what our left and right boundaries are in doing it. And I think that was some good guidance because that has been tested through the constitutionality process. Now, I just got a phone with the Attorney General, and his point is that I have not reviewed in entirety either of these bills, and have not blessed off on either of these amendments. So understand that's where he's at. And what he does is he addresses specific issues that are being addressed. So if we want to take the three that have been brought up as Senator Salama's three demands, first one is change the citizenship checks performed during the voter registration. All right, during an investigation of citizenship before the registration, when the applicant has signed a voter oath, would violate the National Voter Registration Act. We have provisions in AM 1801 to give the Secretary of State additional taskers related to voter maintenance and citizenship, or voter list of ongoing maintenance issues. And to have to gin up a whole new system for voter ID as far as the verification of it is an expense, and it is a big expense. And I will have them work up where in her bill this expense is, but depending on the figures you want to work with, it's in the 20 million range. It is a major expense, and it's not needed. Our system is not broken, and what we're trying to do now is figure out how to give voter ID and not to have the additional expense or the burden on the Secretary of State's office. If it's not broken, I'm at a loss on why we're trying to reinvent this process of voter ID that we currently have. We're trying to work through the issues so that we have in-person voting on election day, that early voting at elections is done efficiently and effectively, that we don't affect the early voting by mail. And for the rule, folks, we have to figure out how to make sure that the mail-in election part of it is done efficiently and effectively. Now, we talked a little about the attestation earlier, and this is where you need to try and visualize what we're talking about. If you have that ballot and you simply are putting down that ID number that then you can correlate to an individual, which has a photo and a name, that is much different than trying to do that through a process of signatures. And the other part of getting the signature, of course, is that you're trusting that person to look at the ID and understand whether it is a valid ID or not. The other system,
1 minute.
which, you say time?
1 minute.
1 minute, thank you. With that, what you're doing is you're taking the ID and you have a direct correlation to a person and not trying to verify signatures. And the person who is trying to validate that signature has no base of knowledge like a government official, state official would have to make sure that that is a valid ID that they're signing and oathing to. So just remember these things as we go through this. This is a major, major change from what the government committee bill is. Thank you, Mr. President.
Thank you, Senator Brewer. Senator Erdman, you're recognized.
Thank you, Madam President. Good afternoon. Listening to the debate today and the different proposals or ideas that are presented, there was another voter ID bill that was submitted to the committee. It was the LB 230. I submitted LB 230, and in my opinion, of course, it's a little prejudice. I think that was the best bill submitted. It didn't catch any traction there. We had several people testify in favor. I didn't arrive at the committee or stay at the committee or contact the committee and work that bill because I thought it was a common sense approach and people would see that it was that and would decide to use part of that or all of it as their choice. That didn't happen. I understand that's how things work. There's another issue that I don't think we've even discussed today, and that is voter integrity. Whether you believe our elections are fair and whether there is any kind of discrepancies or not, that's up to you. But if there is, I introduced a bill that would have solved that whole problem. Now, it was a very common sense approach. And as I've said numerous times, common sense is a flower that doesn't grow in everybody's garden, so it didn't catch on. It was very simple. You voted on Tuesday, a Tuesday in May and November. You showed an ID. You voted on paper. That paper ballot was then counted at the precinct level by hand. And then the vote number was totaled, placed in the box and taken to the courthouse or the clerk. And then they recorded it, no connection to the internet, no messing with how the vote was counted. And it would give a provisional ballot or an opportunity for people who were disabled or couldn't make it to the polls, an opportunity with verification that they couldn't get to the polls, that they could get a mail-in ballot. That solves all of the voter integrity issues, all of them. And I got many emails about that people couldn't make it to the polls. And when one of the testifiers testified about 228, he related this story. He said, 2,300 years ago, there was a couple that was required to go to their hometown for a census. She was 9 months pregnant. She rode on a donkey. He walked beside her, and they made it. You may remember those people. Their names were Joseph and Mary. So my attitude was, in this modern day and age with the convenience we have, there would be occasions people couldn't make it, but the majority of them would find it more easier than Joseph and Mary did. That bill didn't advance either. But if you want to fix any kind of opinion about voter integrity, that's how you do it. We used to do it that way, and it worked quite well. But that bill is dead in the water. It's not coming back. But having voter identification is very important.
1 minute.
But if in fact, and I'm not saying there is, but if there is an issue with voter integrity, this voter ID thing won't fix that. No, I'm not saying there is. I'm just telling you that that's a separate issue. And so we will pass something. I don't know whether it's Senator Brewer's government committee amendment or Senator Slama's, but we will pass something because we have to complete this before we go home. This is not an issue that we need to come back for a special session. Thank you.
Senator Ballard, you are recognized.
Thank you, Mr. President. Would Senator Slama yield to a few questions?
Senator Slama, will you yield?
I would love to.
Perfect. Senator Slama, I think you talked a little bit on your opening, but can you kind of rehash the audit process?
Absolutely. So under our audit process for the signatures of witness attestation, we're aiming not to get the one-off who signed a form not knowing which ID a voter could use and they happen to fail to not know the law. We're not looking for that at all. What we're doing is a back-end process on this audit through the Attorney General's office, in which the Attorney General will take a statistically significant number of signatures, which in this case on an average voter roll would be about 1,000 signatures at the back end of an election, run them through checks and make sure there are no widespread issues with the witness attestation signatures. If it warrants further investigation, my understanding is that the Attorney General will then move forward, going into more detail and analyzing more signatures.
Perfect. Thank you. And then one more question.
Absolutely.
The exceptions. Can you kind of highlight the exceptions in your current amendment?
Absolutely. Two of the major exceptions we have, and a key difference between the Evan Amendment and my amendment, is that we actually delineate and specify the exact groups of voters that the Supreme Court says that we have to have exceptions in some way, shape, or form to photo ID for. First off is those with a religious objection to being photographed. The key difference between the Evan Amendment and my own amendment is that those people in my own amendment with a religious objection to being photographed would notify their county election official, and they would go through a process in which they're given an ID with a picture of their signature. So you're still presenting a photo ID without invalidating that person's religious exemption. On the evidence side, you simply have to call in every single election cycle to your county clerk and reaffirm that you have a religious objection to being photographed. Then you don't even have to show any form of identification, photographs aside. The second group that we specifically target as being covered in my amendment are those who are absolutely, no matter through effort of Secretary of State, come hell or high water, cannot get the documents they need to show that they are a citizen, to get the IDs presented. They're the Secretary of State in that extremely rare instance. I can see that only happening after a reasonable investigation and a reasonable effort by the Secretary of State's office, happening in maybe one or two cases. In that case, the Secretary of State would create an ID with that person's photo through their own office, confirming that they are eligible to vote.
Perfect. Thank you. Thank you, Senator Solomon.
Thank you.
Thank you, Madam President.
Thank you, Senators Ballard and Slama. Seeing no one else in the queue, Senator Slama, you're recognized to close on your amendment.
Thank you, Madam President. So I'm really grateful for the discussion this morning and this afternoon on voter ID. I respect this process, and I also respect the voters of the state of Nebraska. Every single one of us took an oath when we came in here to uphold the Constitution of the state of Nebraska. And after November 2020, our Constitution reads, sorry, let me bring up the actual constitutional amendment language. This kind of ruins the drama of my point, but I will get there. Getting my binders confused. That before casting a ballot in any election, a qualified voter shall present valid photographic identification in a manner specified by the legislature to ensure the preservation of an individual's rights under this Constitution and the Constitution of the United States. With the amendment I'm presenting to you today, I'm asking that you green light an amendment that's received months of consideration, that's far more ready for prime time than the Evan Amendment that was just recently passed. I ask that you put us in a stronger position as a legislature to stand up in court against any challenges that this voter ID bill may bring. I'm asking you to address clear constitutional hurdles that I've outlined several times in the Evan Amendment. I'm asking you to stand on the side of the voters of the state of Nebraska who overwhelmingly voted in favor of voter ID. I'm asking that you stand with them in supporting an amendment that says that you have to show a photo ID in order to vote. The Evan Amendment is voter ID without voter ID. And I'm asking that you stand with me in voting in favor of AM 1883 to give us the voice of the voters of Nebraska back in this place, to give us a constitutional footing to move forward and negotiate, and to be in a conservative place where we can move forward with negotiations that are rooted in the language that voters overwhelmingly approved in November, not simply the path of least resistance. Thank you, Madam President, and I would like a call of the House.
Thank you, Senator Slama. There's been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. record, Mr. Clerk.
22 nays, 22 ayes, 2 nays, place House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Decay, Armendariz, McKinney, Bostar, McDonnell, and Hansen, please return to the chamber. The House is under call. Senator Decay and McDonnell, please return to the chamber. The House is under call. Senator Slama, we're lacking Senator McDonald. Would you like to proceed? The question is, shall AM 1883 be amended to AM 853 of LB 514? All those in favor, vote aye. All those opposed, vote nay. Have all those voted who care to? Mr. Clerk, please record.
8 ayes, 22 nays on adoption of the amendment, Madam President.
The amendment is not adopted. Mr. Clerk, for the next item. I raise the call.
Madam President, next item, Senator Slama would move to amend the standing committee amendments with FA 138.
Senator Slama, you're recognized to open on your amendment.
Thank you, Madam President. So I appreciate that vote. I actually got more votes than I anticipated. But when I'm bringing that amendment and when I'm discussing the constitutional issues with the Evnen amendment, I'm doing everything in my power to save us from going to a special session. I'm also laying the groundwork for everybody to make edits to the Evnen amendment as they see fit. I understand that using my amendment as a starting point after the Evnen amendment came out of the government committee probably wasn't ideal, but I look forward to discussing the constitutional issues with this amendment and talking about where we go from here. So I'm actually interested, so reading from the handout from General Brewer, not General, I'm really sorry, I gave you a promotion there, it's Colonel Brewer, on this bill, the way from the handout, unfortunately, the way her bill addresses these issues would violate federal law or impair protections we already have. And the only, here we go. Here are the points, and I'm going to read them aloud because I'm going to think as I'm on the mic and process these live. Requiring an investigation of citizenship before registration when the applicant has signed a voter oath would violate the National Voter Registration Act. We have provisions in AM 1801 to give the Secretary of State additional taskers relating to voter list maintenance and citizenship. Voter list maintenance is always ongoing. My quick response to that is no, it's not. And also there's nothing authorizing or mandating any entity like we have in our language in the Slama Amendment, which was just unfortunately voted down. There's nothing empowering the Secretary of State to do anything more than what they're doing right now than with the DMV motor voter list, which only covers about 55% of IDs used right now in order to vote. Requiring a notary public or witness for out-of-state overseas and military worker voters is a violation of the Equal Protection Clause of the United States Constitution. It also violates the Uniform and Overseas Citizen Absentee Voting Act. The problem, again, here is that other states do it, and they do it with a strict notary requirement. We're actually making my amendment broader with the witness attestation and notary requirement. The biggest issue I have here with the Evnen bill is that there's no means of verifying that the person is who they say they are when it comes to mail-in voting. It's a fraud-friendly amendment that I've fleshed out pretty thoroughly. And if we're not going to use witness attestation or notary like the overwhelming majority of other strict voter ID states use, I'm open to suggestions rather than just shaking your head no and burying it in the sand. Other states successfully do this. I don't know why our Secretary of State's office can't find the capability within themselves to follow through with the will of the voters. 3, the reasonable impediment certification is a fail-safe. Providing this sort of problem-solving process is important for any constitutional analysis similar to the one used in the Crawford case. Now, that's just a complete misread of the Crawford case, and I'll go into that on one of my next turns on the mic. Here's the problem, and here's the problem that's been the case since day one with this bill, is that the voters gave us a very clear mandate that we, as a legislature, have to follow through with the photo ID, voter ID framework. The Secretary of State is clearly pushing for a weak voter ID framework. That's ideally what he'd love to do. He'd like to do less work. I get it. The problem is that the voters demanded that we have a strict photo ID, voter ID law. And in doing so, we have to take lessons from those with strict voter ID. Now, the Secretary of State continuously fails to do that, especially in his own amendment with the constitutional issues I've outlined, and I will now outline up until cloture time. And I get it. This is the path of least resistance. The Secretary of State signed off on it, so you've been told it's a clean bill. I am up here with years of experience and years of experience behind me in working with previous introducers of voter ID and election law experts and telling you this is not a clean bill. And until somebody gets on the mic with the authority to do so and tells me that they are going to work in good faith on these 3 items, I'm not going to believe it, and I'm not going to stand down, and we're going to burn through time on the floor that we don't have because I don't want us to go to a special session. Like, I'm going to give us as many opportunities as I can to where I'm not rolling back here in October and my first speech opening on any of this is I told you so. Because I get this is a very dry thing. Very few people really dig into the election law statutes, and that's all right. But it's really important that when we do, we do so thoughtfully. And unfortunately, we're being guided by the Evening Amendment. Just to give you a heads up, the Secretary of State is batting 0% when it comes to challenging constitutionality before the Nebraska State Supreme Court during his time as Secretary of State. So you can side with the person who's batting 0% on that end, who's just shaking his head no at everything that gets presented. Or we can learn from the lessons gained by other states and other case law, which is what we've done in my amendment. It's what I've done in the changes that I am proposing to happen with the 3 changes that I'm requesting from the Evening Amendment. The 3 changes I'm requesting are actually getting teeth to the citizenship checks. Right now, the citizenship checks would only cover about 55% of voters. And moreover, the timing of it gives people no due process and removes them from voter rolls without even notification. Point 2 is witness attestation notary. And you know what? If there's some other way that we can verify mail-in ballots to ensure that people are who they say they are and that they're following through with the language of our Constitution and noting that they have presented a valid photo ID in order to vote, that's fine by me. But at the end of the day, we have to have some sort of verification for mail-in voting. Otherwise, you're adopting a fraud-friendly path of least resistance that goes directly in the face of the constitutional amendment, goes directly in the face of the voters who overwhelmingly approve voter ID, and will not hold up in court. Now, 3, the reasonable impediment language. The Secretary of State is correct in that you do have to have pressure relief valves. However, you don't have to have reasonable impediment language that anybody and everybody can point to and say, I have a reasonable impediment for voting. I still have not received an explanation from anyone, including the Secretary of State's office, as to what standard would be used. So you have 1 of 2 standards that I've already talked about, and I'll talk about again. The first standard is any reasonable impediment that somebody says is a reasonable impediment counts as a reasonable impediment. That runs in clear violation of the state constitutional language. On the other hand, if you're saying that there is some sort of standard determined by the county clerks or election officials for what a reasonable impediment is, then you're running into a Bush v. Gore problem, 14th Amendment, that says that you can't have different standards for different counties when it comes to eligibility to vote. And for example, this is like saying that someone in Dakota County might have a reasonable impediment that's determined to be reasonable by their county clerk. They could say, my dog ate my ID, and that wouldn't fly with the Otoe County election clerk. These are 3 extremely clear issues that I am outlining now. And I'm just asking for somebody to get on the mic and tell me I'm going to work, I commit to working with you on these issues. Like, that's all I'm asking for. Because right now I'm bringing up these very clear issues. I feel like I'm the canary in the coal mine going, we're going to have a special session if we pass this bill. And I promise you, we're going to have a special session if we pass this bill because it is voter ID without voter ID. And this isn't for anybody on the floor who's stuck around to listen to debate on this, and I'll take this until whenever cloture is. But for the folks at home, if you voted for voter ID and you think that somebody should show a photo ID to prove that they are who they say they are in order to vote, you should be reaching out to your senator right now, and especially based on the last vote on the board.
1 minute.
Thank you, Madam President. And asking them why you don't support the will of the people. Like, this is a very clear problem I'm working to address here, and I'm going to do everything I can, even if it means standing up here for 8 hours myself until I get a guarantee from someone that this is going to get worked on, because this stuff hasn't even been reviewed by the Attorney General yet. That's the craziest part about this whole thing. This amendment has not been reviewed by the Attorney General. When it comes to constitutionality, we don't have an official take because the Attorney General hasn't looked at it. So I would invite you to stand with me in asking for a review of these issues as we go into next round, and until that happens, voting against cloture. Thank you, Madam President.
Thank you, Senator Slama. Senator Erdman would like to recognize the following guests. Mr. Tim Horn and Mrs. Kelly Horn of Hemmingford, Nebraska. Please stand and be recognized by your Nebraska Legislature. Senator Conrad, you're recognized.
Thank you, Mr. President. Good afternoon, colleagues. I wanted to rise in support of LB 514 and the Government Committee amendment, and rise in opposition to Senator Slama's floor amendment, FA 138. As an important point of just general engagement and education for all new members, I just wanted to make sure that the record was clear and that new members were clear about how a special session happens and when a special session happens. It doesn't automatically happen at all. It's governed by the Constitution and it's governed by state law. And it happens in two ways. One would be if the governor were to issue a call for a special session. The second way for a special session to occur is if 10 state senators initiate a process and start a request that is administered by the Secretary of State's office, and then that is essentially sent out and meant to poll or seek affirmation from additional members to see if there are, in fact, a supermajority of 33 senators who would agree to call themselves into special session. So that's how special sessions are called. And I appreciate and understand that Senator Slama and other stakeholders are incredibly and rightly concerned about having to reconvene for a special session on this or any other topic. But special sessions do not just happen. Special sessions go through a deliberative process. They are called by the governor or a supermajority of senators. And they are to address extenuating circumstances that would not be foreseen during the course of the legislative session. It doesn't appear that those kinds of circumstances are in place in regards to this matter. Now, we also have to remember we do have elections coming forward next year in 2024, and we do need to give enough time to the voters, the election officials, and all stakeholders to update policies, procedures, rules, and regs, do training, do education, order the appropriate materials to make sure that we can carry out the will of the voters as expressed at the ballot box in November 2022 in regards to how we implement the voter ID measure. I think the other thing that's important to be clear here is, Senator Slama is absolutely right. Different attorneys can look at existing case law, at different statutes, and come to different conclusions as to interpretation or application. She has been very straightforward in regards to her interpretation and application. I would note that my perspective, that of committee counsel, that of other lawyers who are looking at how we best implement these measures, have come to a different conclusion. And that conclusion is that the government committee approach is divorced from politics and personalities and adheres to the existing guidance as we understand it under the federal constitution, the state constitution, federal voting rights laws, state voting rights laws, and corresponding case law. The final point I will note on that topic is, of course, it's how we make our case as attorneys, where we argue whether or not certain precedent applies to the issues at hand. I would respectfully disagree with my friend Senator Slama in regards to whether or not Bush v. Gore is the prominent controlling authority. Thank you, Madam President, in regards to this issue. I would contend that it is not, but rather the Crawford opinion is more on point and analogous to the situation before us. Finally, when it comes to Gore v. Bush, I think it goes without saying, of course, that this is widely held across the political spectrum as one of the most notorious and perhaps poorly received and poorly analyzed cases in Supreme Court history. So it would be always, I think, a little bit shaky to rely upon that. And what that looks at is vote counting, not how we cast our vote, which is what we're talking about in voter ID. Thanks, Madam President.
Thank you, Senator Conrad. Senator Blood, you're recognized.
Thank you, Madam President. Fellow senators, friends all, I'm just going to speak real briefly. I am against the floor amendment, but in favor of the government amendment and the underlying bill. And I have to say, I don't ever get involved in constitutional discussions because I don't fancy myself a constitutionalist. The only time I talk about Constitution is when we blatantly take away constitutional rights like we did on Friday from parents on that bill. But I will say also that when I'm told that we have to wait for something from the Attorney General, I've never been really impressed by what we get from the Attorney General's office. We recently got some information from the Attorney General's office that was basically not an answer. It was just a bunch of mumbo jumbo. And I look about how when we had complaints about the petition process to get this bill on the ballot, that it was never taken seriously, because if you can prove deception, which we were able to do, then that particular list on that petition drive is supposed to be invalid, and that was never done. So the fact that we're waiting to hear something from the Attorney General's office doesn't impress upon me that I want to do anything. What I want to do is listen to Senator Slama and Senator Brewer and hear what their pros and cons are, and I'll make a decision based on that. But to be told that we need to have more information from the Attorney General's office, they're going to have to start doing their job in a way that influences me better, because from Meade, Nebraska, with the previous Attorney General and never taking action on that, to the most recent decision that they shared with us, I am unimpressed. But with this, I would be more than happy to yield any time I have left to Senator Slama.
Senator Slama, you are yielded 3 minutes, 15 seconds.
Well, thank you, Madam President, and thank you very much, Senator Blood. I do appreciate your point on the Attorney General's input and his thoughts. It's just as ludicrous to me as it is waiting on that to pass a bill is just as ludicrous as having a member of the executive branch in your executive committee meeting in which a vote's taken, where that input from the executive branch member that's shuttered away from public view and only in the view of the committee members and the news media. And that's why I objected to the process here. But I do like your feedback, and that's why I'm really trying to narrowly focus my concerns with this bill on the 5 core constitutional issues. Do I have more issues with this bill? Absolutely. But I do think that this bill lives and dies on 5 failures in my mind to follow either the federal constitution, federal law, the state constitution, or other precedent that's been set controlling case law. So just a quick overview of that, and I'm going to get back into reading this full memo again, especially as I wait for my staff to bring me the full text of the Bush v. Gore decisions and the Crawford decision, so we can just read them aloud together. Because I do think there is this aura among certain people of, oh, this person's a lawyer, so they understand the law better than I do. We might have sometimes more experience when it comes to it, but at the end of the day, if you can be literate, you can get like 90% of the law. Like law school is just teaching you the right things to look for in a case. So we're going to read those cases together, and I'm going to give you my takeaways from those cases because we do have time, and I think this is a very, very valuable thing to be allotting a lot of time to on the floor. So we've got 5 main constitutional issues with the Evnen AM, which we've now adopted and confirmed we're going to continue to support. Section 5 violates the National Voter Registration Act, NVRA. Sections 10 to 11 places an undue burden on fundamental right to vote. We've got case law directly on point on that one. It also violates the amendment. Thank you, Madam President. The amendment passed by voters by allowing non-exempt persons to vote without showing a valid ID. Section 12 violates religious objectors' fundamental right to vote as outlined by the United States Supreme Court. Section 17 through 19 either violates the fundamental right to vote or the Equal Protection Clause as articulated by the United States Supreme Court. In Section 23, when taken with the rest of the amendment, violates the Privileges and Immunities Clause of the 14th Amendment. That's all I have on this turn on the mic. I assume I might be up next, but if not, and I have a quick break, that would be wonderful. Thank you, Madam President.
Thank you, Senator Slama, and indeed you are next in the queue.
Oh, dandy. It's like every day's Christmas. All right, so starting back up with this memo, and I do think it's important to get it in the record several times in full, just to really drive the message home that the complaints I'm making here are clear, concise, to the point, and on point. And I'm hopeful they can direct discussions between general and select files so we can fix clear issues with this amendment before we end up passing something that's taking the easy way out into law, where we're going to be stuck in a court case where the court, based on my reading, will absolutely not uphold this. So Section 5, violating the National Voter Registration Act. Secretary Evnen said that he would use Section 5 of this amendment when people register to vote so as to prevent non-citizens from getting on the voter rolls in the first place. However, that is not what his amendment does. Section 5 of the Evnen Amendment states, the Secretary of State shall develop a process to use the information in possession of or available to his or her office to match and verify the citizenship of the corresponding registered voter. This use of the term registered voter rather than applicant or some other term clearly shows that it only applies to somebody that is already registered to vote. Removing someone who is already registered to vote is a clear violation of the National Voter Registration Act. 52 U.S. Code 20507A3 indicates that a registered voter can only be removed from the voter rolls in 4 situations. The voter requests to be removed, the voter died, the voter moved, and certain criteria were met, or the voter was convicted of a crime that disqualifies them from voting. A simple citizenship check using DMV data prior to removing a person from the voter registration rolls does not meet any of these situations. That is why my amendment requires an investigation and prosecution, so due process. The Secretary's amendment is a clear violation of the NVRA. So what this amendment would lead to is folks that fall into a loophole that might have been convicted of a felony 5 years ago and finished serving their sentence 3 years ago, to where they get pinged as not being an eligible voter. Not only would they not receive any notification that they were removed from the voter rolls, but they would be lining themselves up for a case of being accused as a non-eligible voter under this amendment. If you care about due process and you care about doing things the right way and giving people notice before they're breaking a law, I'm telling you right now that this amendment does not provide any kind of notice. It does not fulfill the needs of due process, and it does not fulfill the language of the NVRA. Sections 10 and 11 place undue burdens on the fundamental right to vote. Sections 10 and 11 of Secretary Evnen's amendment is unconstitutional because the affidavit requirement is confusing and ambiguous. Those are words tabbed by the court. They're not just adjectives that I'm using lackadaisically, and could even pass rational basis review, which is actually a very impressive thing to do. Under both the United States Constitution and the Nebraska State Constitution, voting has been found to be a fundamental state right. Burdens on the fundamental right to vote are subject to 2 different levels of scrutiny depending on the burden imposed. The level of review relevant here is rational basis review, and I'm basing that off of the Burdick versus Takushi case decided by the Supreme Court in 1992. In a case directly on point, the Missouri Supreme Court found that a confusing and ambiguous affidavit failed the rational basis review and that was therefore unconstitutional. The evident amendment on the affidavit says that a voter who has a reasonable impediment to voting does not have to show an ID, but it does not define what reasonable impediment is. The voter has to fill out an affidavit claiming a reasonable impediment. The affidavit restricts the voter to checking the box for 3 possible, thank you, Madam President, 3 possible and reasonable impediments, but a voter may legitimately believe that their circumstances qualify as a reasonable impediment under the amendment language, but is not listed on the affidavit. If the amendment wanted to limit reasonable impediments to those listed on the affidavit, it should say so both in the text of the amendment and on the affidavit so as not to confuse voters. Because it does not, the affidavit is ambiguous and confusing to the voter under the logic of the Missouri Supreme Court, then it fails the rational basis review. And I'll continue on my next term on the mic. Thank you, Madam President.
Thank you, Senator Slama. Senator Hansen, you're recognized.
Thank you, Madam President. Going through emails and phone calls about this bill, I did receive a phone call from one of my constituents in Stanton County. And Stanton County is one of those 11 counties in Nebraska that conduct elections entirely by mail. And so he wants to know, as a rural widowed Nebraskan, how do these amendments affect his ability to vote? Do these require him to go chase down somebody in the county to consider his valid vote? With that being said, I did have a question for Senator Brewer that would pertain to that, possibly. But I wanted to ask the same question of Senator Slama. I'm just, on behalf of my constituent, get an idea on how each of their perspectives would affect his ability to vote with the mail-in ballot that they have. So, Senator Slama, would you yield to a question?
Senator Slama, will you yield?
Yes.
So, what would your amendment require from the voter that I just mentioned earlier of these all mail-in election counties?
Yes. In the case of that voter where they have nobody at the house, they have nobody to go to, they can go to like literally anybody in the county election office. They'd be required to help them out. They can also contact the Secretary of State's office, who's meant to have a reasonable amount of outreach and can get that voter taken care of. They'd also have the notary option. I think in this case, they'd prefer some variation of witness attestation to make their lives easier.
Okay, thank you very much. Appreciate that. And I appreciate you getting up here and explaining your perspective a lot more that we can all listen to, and I encourage all my colleagues to listen as well. And so with that, will Senator Brewer yield to a question, please?
Senator Brewer, will you yield?
Yes.
So I know you have a couple of counties as well in your district, Cherry and Dawes County, that also do the all mail-in ballot, one of the all mail-in ballot counties. So what does the government committee amendment require from the voter of these all mail-in election counties?
All right, we'll go back and kind of rehash some of this with the attestation or the signature. One bill requires it, one doesn't. Mine requires that you put on that ballot your identification, whether that be a state ID or whether that be your driver's license. That is then the Secretary of State is then able to look at that and confirm that that is the person who has sent that ballot, the names match, and that's how they complete that cycle to understand who the voter was.
All right. Thank you very much. And I appreciate both senators answering this question on behalf of one of my constituents. I hope this clears things up for them and maybe some others that are in some of these like counties as him. So with that, thank you, Madam President.
Thank you, Senator Slama, Brewer, and Hansen. Senator Slama, you're recognized, and this is your third opportunity.
Good golly gosh, thank you very much, Senator DeBoer. I appreciate that. And I appreciate Senator Hansen's question because it drives home the key focus of, at least my perspective, of when we were negotiating this bill, this amendment, everything to do with this bill. Two main things were on my mind. Is it constitutional, and is it workable? So the workable language we have covered with the witness attestation and notary requirement that over a dozen states have at least some variation of. Like Rhode Island requires 2 witness attestation signatures. We just require 1. And then the other question becomes, is it constitutional? Now, one of my biggest concerns with the Evening Amendment, as I've discussed several times before, is that there is no back-end verification on those mail-in voting ballots. So you have 2 options under the Evening Amendment when you do a mail-in vote. One is put an ID number. The second is a copy of your eligible ID. Copy of your eligible ID, fine, we can just debate that and discuss that. My core problem is with the ID number, which I understand is necessary because if you just have it be a copy, you run into issues with, well, who doesn't have access to a copier? I understand why you include the language, but given the wide range of IDs allowed, like any political subdivision can issue an ID under this amendment. There's no means of the Secretary of State verifying that ID to ensure that you are who you say you are, or even that you're using a valid ID. So for me, this is a key difference between our 2 bills. There's no language, even if the Secretary of State wants to point to and says that there is language, if you can't point to the line in the section of the bill where that language lives, it doesn't exist. And every reading I've had of that bill is that that language doesn't exist. And that's a huge problem for me because we want to make sure that the mail-in voter in Douglas County is held to the same standard as the in-person voter in Dawes County. It's a matter of every voter in the state having to show a photo ID in order to vote unless they fall within a very narrow list of exceptions. So back to my concerns about the constitutionality of the Evening Amendment. This is discussing sections 10 and 11, placing undue burdens on the right to vote. While the Missouri Supreme Court case is not controlling, a Nebraska court or a federal court would analyze the amendment under that same standard, so rational basis test. Therefore, we can be confident that this amendment places an undue burden on the fundamental right to vote under both the United States Constitution and Article 1, Section 22 of the Nebraska Constitution. Section 10 and the associated sections of Secretary Evan's amendment violates Article 1, Section 22 of the Nebraska Constitution by failing to actually implement the voter ID provisions required by that article. And the language is, and it's so important we get this on the record several times because this is our framework for how we're meant to be moving forward. Before casting a ballot in any election, a qualified voter shall present valid photographic identification in a manner specified by the legislature to ensure the preservation of an individual's rights under this Constitution and the Constitution of the United States. It requires the legislature to pass a law that says how somebody shows an ID, not whether or not they have to show an ID. It's not ambiguous at all when it comes to that. At the same time, hierarchy of laws demand that this provision passed by the voters be interpreted as consistent with the United States Constitution. So the Constitution is the highest law of the land there, and then a little bit further down is the state constitution. In Crawford versus Marion County Election Board, thank you, Madam President. The U.S. Supreme Court found that under the United States Constitution, there are only select groups of individuals that may receive special accommodations under voter ID laws. They include elderly persons born out of state who may have difficulty obtaining a birth certificate, persons who, because of economic or other personal limitations, may find it difficult to either secure a copy of their birth certificate or to assemble the other required documentation to obtain a state-issued identification, homeless persons, and persons with a religious objection to being photographed. This is a case from 2008, and it's very helpful in guiding our knowledge. And I'll come back and continue this on my next turn on the mic. Thank you, Madam President.
Thank you, Senator Slama. Senator Conrad, you're recognized.
Thank you, Thank you, Madam President, and good afternoon, colleagues. I continue to rise in opposition to the floor amendment and in support of the Senator Brewer's amendment and the underlying bill. I wanted to just make a few additional points that may be instructive and helpful for members who I know are carefully listening to the debate to have some additional context beyond just the dueling amendments and approaches that are before you on display in the debate today, and that you may have been keeping track of over the last couple of weeks and months in kind of, I guess, dueling social media or traditional media kind of recounts of where we are in the process, and kind of further explanation illuminating the approach that 92 out of 93 county clerks and election commissioners are taking, along with the Secretary of State and the majority, almost a unanimous majority of the government committee, and then the approach that Senator Slama has decided to chart, which of course is her right to do so. I want to also make sure that members are aware, for folks who haven't had a chance to work kind of on the front lines of some of these voting rights issues, maybe as deeply, but as a civil rights attorney, and my husband and I were just kind of chuckling that we met in law school and we're in the same law school class, and I think it was 20 years ago this May that we graduated from law school. I've spent the entirety of my career working for working families as a civil rights attorney and as a member of the legislature, so I've had a distinct opportunity to be able to work on a lot of these voting rights issues over the years. And I want to share just a little bit of background without getting too deep into the weeds, because I'm far more of an enthusiastic student than I am an expert when it comes to kind of the back end administration in regards to ensuring integrity of our voter rolls. But there are a host of existing laws, policies, and procedures in play when it comes to making sure our voter rolls are secure and that they are accurate. That is not a process that is regulated to kind of a Wild West approach. It's highly, highly regulated. So, for example, Nebraska's their county election commissioners, county clerks, and the Secretary of State's office work periodically with a host of different stakeholders to make sure that our electoral rolls, our voter rolls are accurate and have integrity. So they're constantly doing appropriate checks, safeguards, and cross-checks with, say, for example, the criminal justice system, with USPS, with vital records, with other critical stakeholders, coordinating with ERIC, I believe, to make sure that our voter rolls are appropriate, are up to date, and to ensure that those who are ineligible to vote for a variety of reasons do not remain on the list. But also taking great care to ensure that those who are eligible to vote are not needlessly removed. Because, of course, both of those outcomes are abhorrent to democracy. We do not want non-eligible voters to vote, and we do not want eligible voters to be denied from voting. And that's why we don't have to come up with a novel plan.
1 minute.
Thank you, Madam President, to implement voter ID. We can take into account the existing legal framework when it comes to things like citizenship, when it comes to things like voter integrity, when it comes to things like how to implement voter ID, and that is the deliberative, careful process that the Secretary of State, the vast majority of election officials, and the government committee has put forward. I respect and appreciate Senator Slama's right to chart her own course, but it is an opposite to what the lessons teach us in terms of the case law on point. Thank you, Madam President.
Thank you, Senator Conrad. Senator Brewer, you're recognized.
Thank you, Madam President. All right, let me go back and stress to you that I am not an attorney. I appreciate Senator Conrad being one and being able to address issues that she has a good working knowledge of, and that was part of the discussions that we had in the committee hearings. For those that are starting to question, well, you know, is the committee just all ate up and did they lose their focus? Is there some crazy thing going on here that would cause us to start doubting this whole process? I ask you to remember that 92 to the 93 county elections officials weighed in support of this bill. We have the government committee. So it's not like this is a crazy Ivan that we just pulled out of our hat and we're throwing out there. And there's a point I can only listen to so much without coming back with some feedback here. If you look at 1801, page 1, you go to line 12, and what this does is it starts breaking out the whole process, the photo ID and identification. And in there it talks about the United States issued identification, state of Nebraska, an agency or political subdivision of the state of Nebraska, and post-secondary institutions within the state of Nebraska. Okay, that's fairly clear and forward. And you drop down to number 2, it says the document issued by the United States Department of Defense, United States Department of Veterans Affairs, Veterans Administration, any branch of uniformed service as defined in section 85-2902, or any Native American tribe or band recognized by the United States government. Then below that, it goes into a little more detail, which shows the name of the individual whom the document was issued, shows a photograph and digital image of the individual whom the document was made for. And then it goes into hospitals, assisted living facilities, nursing homes, or other skilled care facilities. If we take and flip over, and you have in your black binder, to page 1 on LB 535, and you go down to number 3, and here we talk about a document issued by the government agency or political subdivision that stratifies all of the following: that the document shows the name of the individual to whom the document was issued. The name confirms to the name of the individual voter registry record. The document shows a photograph or digital image of the individual to whom it was issued. Let's see, one of the items listed as evidence of lawful status in the subdivisions through of section 8484.04. This provided by individuals as part of the issuing process of the document. The agency or political subdivision that issues the document provides the lawful status information from the item provided pursuant to the subdivision, and this subdivision to the Secretary of State. If you keep reading down, the bottom line is that when we come to this issue of trying to verify your ID, this paragraph 3 is kind of the wild card that says ID items, any political subdivision.
1 minute.
The issue of subdivision keeps coming up. And if you compare the reading of these two, and that's where we're going to have to go with this, because we're going to go back and forth on lawyer stuff all day, but just go black and white and tell me which one is cleaner and easier to understand. And I think if you do that, the logic will carry the day and you'll understand why the committee did what it did. Thank you, Madam President.
Thank you, Senator Brewer. Senator Slama, you've already spoken 3 times, but there's no one else in the queue, so this is your close.
Outstanding. Thank you, Madam President. I knew that. I was just overexcited to respond to my friends and colleagues, Senators Conrad and Brewer, on their points. So this letter that was signed by 92 out of 93 election officials in the state of Nebraska has been brought up a lot. And there was actually a rule in our negotiations to not give that letter weight, because at the end of the day, what happened with that letter and how it was coordinated, I've had several people reach out to me and express regret at signing on to that letter and feel as though they were pressured, because they signed a letter that was shoved in front of their face with a 24-hour deadline to sign on, and a lot of pressure that they felt the need that they had to sign on to it to be in line with the other county election officials. So a lot of them, and I'm not saying all of them, feel that they weren't even given enough time to analyze it, more pressure to just go along with the flow, which I feel a lot of us are being pressured to go along with the flow now. Just because a bill is shorter, and it doesn't mean it's cleaner and easier to understand. It's cleaner because the Secretary of State's office said it was. Now the problem is that hasn't been vetted by literally everybody else that was around the table for 3 months negotiating a voter ID amendment. And easier to understand, we all know that that doesn't have any standing with whether or not the courts hold up with an amendment. So just to get back to my constitutional issues with voter ID, with this voter ID amendment, it's called the Evnen Amendment. I just got done with my quote from Crawford. If y'all are excited to hear more about Crawford, I have the full case text and we'll be able to fully flesh out the Crawford case and talk about what it says, because we'll go through the entire Crawford case. But taken with the Nebraska Constitutional Amendment, what this means is that the Nebraska Legislature must pass a law implementing voter ID that only 1, makes exception for those with religious objection, and 2, makes accommodations for all other groups mentioned by the Supreme Court. If we cannot make accommodations for those groups, then they too would be exempt. However, the text of the Constitutional Amendment requires that anybody outside of these groups show a valid ID. The Evnen Amendment and related sections beyond Section 10 go far beyond this by allowing somebody to vote if they're sick or they don't want to get out their birth certificate to get an ID. This last category is very concerning, because the U.S. Supreme Court has explicitly said that having to acquire the appropriate documents to get an ID is not an undue burden on the right to vote. Therefore, the Evnen Amendment violates the Nebraska Constitution, and it betrays the will of the voters that everyone show an ID. My amendment, on the other hand, makes accommodations for all these groups while requiring those who are required to show an ID in order to vote, and even a provisional voting system where if they don't have an ID, they have 7 days to get one if they vote on election day. The Secretary of State is to aid these individuals in obtaining the necessary documents to get an ID. If they cannot, the Secretary of State can provide them with an exemption or provide an ID for them. Again, this is what Missouri does, and they handle all of this with a state that is much larger than Nebraska's, with one person, one full-time employee whose job it is to help out voters. Section 12 violates the religious objector's fundamental right to vote as outlined by the United States Supreme Court. Any infringements upon a person's sincerely held religious belief is analyzed under strict scrutiny, requiring those who have religious beliefs against being photographed to recertify that religious belief would have to recertify that religious belief, and that would be a burden analyzed under strict scrutiny. And it is not the least restrictive means of achieving that. A voter could simply be required to notify the secretary if their belief changes, which is what's required under my own amendment. Therefore, the recertification would fail strict scrutiny, thank you, Madam President, and be an unconstitutional burden on the right to vote. Section 17 to Section 19 would be my next one up, but for the sake of not having to have a floor amendment voted down, I will withdraw this current floor amendment.
Thank you, Senator Slama. Mr. Clerk, for items.
Senator Slama, we've got FA 145, which is exactly the same as your previous FA. Normally that'd be a reconsideration, but you withdrew. Would you like to take up 145 or move on to a new floor amendment?
Wasn't that one striking Section 1 and this one striking Section 2?
You've got multiple striking each section, Senator.
Okay, we'll go to the next one that I'm going to guess strikes Section 2.
Okay. In that case, Madam President, Senator Slama would move to amend with FA 145.
Thank you, Mr. Clerk. Senator Slama, you're recognized to open on your floor amendment.
Thank you very much, Madam President, and thank you very much, Brandon. I do want to take a moment, since I have a longer opening here and only about 7 minutes of stuff worth to read on this turn, to thank some very important people who have been wonderful throughout this process. My amazing staff, 2 of which are under the balcony, my legislative aide, Tori Osborne, my outstanding committee counsel, Joshua Crystalier, Sue Ellen Sussman, my administrative aide who keeps the trains running, and Natalie Shunk, who keeps all the trains rolling on the Banking, Commerce, and Insurance Committee. They're a wonderful team. And I also have to thank those who came before me, who introduced voter ID and have encouraged me to hold strong on this. People like former state senators Legrone, Moranti, Senators Larson and Jansen actually signed a letter in support of my bill for the committee hearing, so their support means a lot. And last but not least, Marcia in the bill drafter's office has been wonderful about drafting the different revisions. And if anybody feels the need to say thank you to Marcia, she loves Diet Coke. So if y'all want to go into a pool with me and buy her a pallet of Diet Coke for putting up with us this session, I'm game to do that and happy to coordinate. But today's battle didn't come with me standing as an army of one, though sometimes it can feel like it. It's come from a lot of wonderful people who have supported me along the way. And at the core of that support are those who supported voter ID, the hundreds of thousands of Nebraskans who voted in favor of Initiative 432 to get voter ID across the finish line. The Nebraska Legislature tried and failed for years to get voter ID across the finish line. It always got filibustered or got blocked coming out of committee. Something always happened to where we couldn't even get it out of the legislature to go to a vote of the voters. So the voters took it into their own hands, successfully lined up a petition drive and got that across the finish line, and then got the vote across the finish line too, with a strong 65% of the vote in support. So I'm just so grateful to everybody who helped make voter ID happen. And everything I'm doing right now is for them. The people who put in hours and hours and hours of their time volunteering to collect signatures, working different events and county fairs to get signatures. I'm just so grateful for your efforts, and I'm not going to let you down by standing down on this one because it's the easier thing to do. I'm going to follow through with your wishes, and I'm going to follow through with the language of the constitutional amendment. So back to my constitutional objections with the Evnen Amendment, sections 17 to 19. So this either violates the fundamental right to vote or the equal protection law as articulated by the United States Supreme Court. Got case law directly on point. It also violates the amendment passed by the voters by allowing non-exempt persons to vote without showing an ID. There are 2 possible interpretations of sections 17 through 19. One is that no one would check to see if the voter actually had a reasonable impediment to vote, thus not actually requiring anybody to show an ID at all. As we already discussed regarding sections 10 and 11, this would fly in the face of the voters and would clearly violate the Nebraska Constitution. So it's voter ID without the actual voter ID. The other interpretation would be that the election officials in each county would be left to interpret whether an individual has a reasonable impediment. With the fact that Nebraska has 93 counties, at a minimum, 93 different election officials would be making separate determinations of whether a reasonable impediment existed. An election commissioner in Scottsbluff County might interpret someone's cold as a reasonable impediment, while an official in Otoe County might say that it is not. Such a possibility would violate the Equal Protection Clause of the 14th Amendment as outlined by Bush v. Gore. I know my friend Senator Conrad and I have a disagreement on that, but what we're going to do is read Bush v. Gore in full on the mic, and I'll let you decide for yourselves. In other words, if this is the correct interpretation and people's reasonable impediments have to be checked, this amendment will turn all of our elections into the fiasco that was Florida in the 2000 presidential election. However, it doesn't just stop there. Since sections 17 through 19, when looked at as a whole, require 3 different election entities, the election official, the receiving board, and the counting board, to make potentially separate decisions on an individual's reasonable impediment, there is a possibility that we could have 279 different interpretations of whether certain claimed reasonable impediment counts. See, there's a reason why other states don't do this, and even states with reasonable impediment language have clear clear constraints outlined, a ceiling, not a floor like this has, because you can run into literally hundreds of different interpretations of what a reasonable impediment is. And also, reasonable impediment isn't language used by strict voter ID states. Nebraska, with the passage of the constitutional amendment, is now a strict voter ID state. You can't just say I have a reasonable impediment like we say I don't have to have a real excuse to mail and vote. We have stronger language on showing an ID than that now. Section 23, when taken with the rest of the evident amendment, Section 23 violates the Privileges and Immunities Clause of the 14th Amendment. The Supreme Court has held that a state cannot discriminate against a person based on where they're from as it relates to exercising a constitutionally protected right. That's as referenced in the Bolton case from 1973. Voting, as I've already stated, is a constitutionally protected right. The Secretary of State Evidence Amendment only pays for the documents required to get IDs for people born in the state of Nebraska. This is such an easy administrative fix that I don't know why we're not addressing. Like, if you're born out of state, it doesn't pay for the documents you need to vote. This is a clear burden on a fundamental right based on the state a person was born in. Thus, Evidence Amendment violates the Privileges and Immunities Clause of the 14th Amendment to the United States Constitution. We're literally lining up two separate classes of individuals. Those born in the state of Nebraska who can get help for free through the Secretary of State's office to get things like birth certificates and whatever in order to get an ID in order to vote. And those who were not born in the state of Nebraska, who cannot get assistance through the Secretary of State's office or would have to pay their own way, which, as we've discussed before, is a clear violation of not having a poll tax and not having to pay to vote. So, if nothing else, this Section 23 needs to get fixed. I don't even care where you're at on strong voter ID versus weak voter ID. That's just a simple thing. And I consider... There's one more section about this. Section 23 and Section 12. I don't care where you're at on pro voter ID or not pro voter ID. If you're getting up here and saying that that language is fine and it's consistent and we should uphold it, why? Why are we saying that someone has to call into the Secretary of State's office every single election cycle to affirm that they don't have, that they have a religious objection in order to vote? Why are we saying that before every special election, every election cycle, that they have to make that call? When if you have a religious objection that's strong enough to be you being photographed, that it raises to the level of you being unwilling to be photographed for any identification, that's not going to change every 2 years. This is just not something that happens. It's a very narrow segment of our population, and it's a clear undue burden on them to call into the Secretary of State's office or the county election clerk's office every 18 months. Section 23, all of us can agree, we shouldn't have two classes of citizens in the state of Nebraska. We shouldn't be implementing a poll tax on people just because they were born outside the state of Nebraska. These are two very clear-cut examples of simple things that need to be fixed with this amendment. It's not a clean amendment. It's not ready for prime time. And that's why I'm going to get up and keep hammering the case law, the relevant issues I see with this. And odds are, unless I really, really need a break and no one else is speaking, that I'm not going to take a lot of these to a vote, just because I don't want to be hauling people in here back and forth. It's not fair to you guys to just take this 8 hours on my own. So with that, thank you very much, Madam President.
Thank you, Senator Slama. Senator Hansen, you're recognized.
Thank you, Madam President. I first want to give my thanks to Senator Slama for all the time and effort she's put into the ballot initiative for voter ID. I know whenever I would text her and she would angrily text something back to me, I know she was stressed over all the work she's put into to doing all of this. So I know it takes a lot of time and effort and work to do what she's done, and all the people that she's thanked also played a huge role in it. I was hoping Senator Slama would yield to a question.
Senator Slama, will you yield?
Yes.
I noticed in the black binder that you sent out, that you have a flow chart about in-person voting. I was hoping maybe a little bit if you could elaborate on that. So I know we talked about some of the mail-in voting parts of how your amendment or what you want to see happen would work. Could you elaborate more, just a little bit, on the in-person voting aspect of that?
Absolutely. Yeah. No, and I'm grateful that we're pointing to charts and using the charts I love visual references, and I think this is very helpful, especially getting, in a way, kind of to Senator John Kavanaugh's point that he raised earlier about how the provisional process would work. So in-person voting, how it would work is you show up to your designated polling place on election day, like this is considering in-person voting on election day. Does this voter have a valid photo ID to present? If yes, they just show their ID, they receive and complete their ballot, and they're good to go. If they don't, say they lost it in a fire or like literally any reason whatsoever, we're not choosy about our reasons. It could be I forgot it at home, my dog ate my ID, literally doesn't matter. That voter will receive and complete a provisional ballot. And then after that, they've got 7 days after election day, so in that provisional voting period, that they must show that valid photographic ID to the election official for their ballot to be counted. And after that, you take one of those two routes and then you vote it.
All right. Thank you, Senator Salama. I appreciate her clarifying some of these questions, not just from myself, but some constituents as well, because we are dealing with a lot of legalese and a lot of the minutia of how this ballot initiative would be implemented in the state of Nebraska from both sides and both ideas. And so I think for us to kind of wrap our heads around this and get a good idea about how we're going to vote, I think it's good that both parties have gotten up here and explained things in detail. So with that, I will yield the rest of my time back to the chair. Thank you, Madam President.
Thank you, Senator Hansen. Senator Conrad, you're recognized.
Thank you, Madam President, and thank you, colleagues. I, much like Senator Slama, find nothing perhaps more enjoyable or exciting as having an opportunity, I think as she put it, or we talked about together off the mic, to nerd out on constitutional law and voting rights. This is, I think, probably every lawyer's dream scenario. So it's fun to be able to debate these important issues together, even if we have a very different conclusion. And that's one thing that I want to point out, and then I want to make sure to provide some context. As Senator Slama said, she's planning to read into the record the Bush v. Gore case as well, just so that colleagues can have some understanding about how that precedent is utilized and whether or not it is applicable to the present sense. But when you have 92 out of 93 election officials come forward and sign a letter, if some of them were pressured, they're always free to provide that information about undue coercion or otherwise to our offices in a confidential manner. We heard from election commissioners for large counties and more rural counties just about implementation issues, which was critically important. And I think everybody agrees that we have super hardworking election officials all across this great state and poll workers, and they have to be partners in this effort. Once we make a policy decision, they're charged with implementing that. And we need to take into account the practical and pragmatic considerations in terms of allowing them to prepare for a sea change in the administration of elections and to take into account the feedback that they have for how to do that and what we've learned from our sister states. So when you have, and let me be clear, I disagree with the Secretary of State frequently and voraciously on a variety of different issues. But I agree with him in this instance. I agree with my friend Senator Brewer in this instance, and I agree with our election commissioners. And what you have there, friends, is not a conspiracy, but a consensus. Multiple people have looked at these issues from multiple angles and find this path the most possible to limit litigation, to facilitate the will of the voters, and to ensure that we don't needlessly suppress voting rights for eligible voters. The other thing that I want colleagues to know in regards to the Bush versus Gore case that was dispositive over a hotly contested presidential campaign back in 2000, which I know many of us watched closely. But if you look just at the initial commentary from the justices in that 5-4 highly controversial decision, and this has been hotly debated, the court itself says this is not meant to be a widespread precedent, but quote unquote, the court says in Bush v. Gore, our consideration is limited to the present circumstances for the problem of equal protection in election processes generally presents many complexities. So that's important to remember. And in the 23 years or so since Bush v. Gore was decided, the Supreme Court has really only mentioned it in passing twice, which shows you what's limited precedential value that the case has when it comes to electoral law. Now, that doesn't mean that litigants haven't sought to utilize that.
1 minute.
Thank you, Madam President, that case in any host of different election-related issues before the lower courts or even state courts. But that definitely should help to provide a little bit of information. The Bush v. Gore case is limited in terms of its precedential value on its face. And it looks to whether or not there's an equal protection issue for the lack of statewide standards in regard to a recount. I do not think we should paint with a broad brush, as Senator Slama is encouraging us to say that an equal protection problem arises whenever there's differences in voting. That's not the case. Look at Nebraska and let common sense dictate. We have 11 counties that are all by mail. We have other counties that chart a different course. That in itself is not an equal protection problem. Thank you, Madam President.
Thank you, Senator Conrad. Senator Slama, you're recognized.
Thank you, Madam President. I am grateful to my friend, Senator Conrad, for further fleshing out the issues she sees with Bush v. Gore, and it's a rather long opinion, so I will get around to talking about it here shortly. But the key thing here is no matter if you look at Bush v. Gore or any other controlling precedent, like the language is key, that you cannot have different standards to be able to vote if you're in a different county within the same state. I get that some of our counties are fully mail-in. That's not what I'm talking about here. And also, if we're saying, it also gets to like this weird logical conundrum of mail-in voting somehow isn't voting, so restrictions on photo ID for mail-in voting shouldn't count because mail-in voting somehow isn't voting, when of course it is. What I'm saying is that you can't have 93 different standards depending on who your county election clerk is as to what a reasonable impediment is. You very clearly have a problem here of vague and ambiguous language when it comes to the reasonable impediment language. All you need to do to address that is clearly outline what a reasonable impediment is and set that as the ceiling, not as the floor. If you set it as the ceiling, you're following what other states like Texas have done, which has a relatively weak voter ID framework, and at least saying, as a state level, this is our standard. Can the voter meet X and Y? If not, it's not a reasonable impediment. If yes, reasonable impediment. That's all I'm asking for. What you're asking is for county election clerks to take on yet another responsibility and be the judge and the jury for whether or not a person's sick note from their doctor is valid. By creating a simple framework on the state level, you're easing those concerns. And that's the only point that I'm making. Like, to me, that's both settled in case law in Bush v. Gore, and we will read the full thing because I've got the time to do that. But first, opinion that I've brought up several times in my constitutionality argument is Crawford versus the Marion County Election Board, decided by the Supreme Court of the United States in 2008. And I'm just going to read the full thing. Actually, I'm going to start with the syllabus, and I'm going to start with the syllabus for each of these cases. That way you can get a short, quick summary of what we're dealing with here, and then I can go into the full opinions if we happen to have the time. Let me hit my button again. After Indiana enacted an election law requiring citizen voting in person to present government-issued photo identification, petitioners filed separate suits challenging the law's constitutionality. Following discovery, the district court granted respondents summary judgment, finding evidence in the record insufficient to support a facial attack on the statute's validity. In affirming, the Seventh Circuit declined to judge the law by the strict standards set for poll taxes in Harper versus Virginia Board of Elections, decided several decades back, finding that the burden on voters offset by the benefit of reducing the risk of fraud. Held, the judgment is affirmed. So the previous court's ruling was affirmed. Justice Stevens, joined by the Chief Justice and Justice Kennedy, concluded that the evidence in the record does not support a facial attack on SEA's 483's validity. Under Harper, even rational restrictions on the right to vote are invidious if they are unrelated to voter qualifications. However, even-handed restrictions, two key words here, even-handed restrictions, protecting the integrity and reliability of the electoral process itself, satisfy Harper's standard. A state law's burden on a political party.
1 minute.
Thank you, Madam President. An individual voter or a discrete class of voters must be justified by a relevant and legitimate state interest sufficiently weighed to justify the limitation. I'll pick up from there later on, but just a note of appreciation. I do appreciate the chance to nerd out on election law. I think we discuss it far too little, and to actually have a substantive back and forth with points and counterpoints is something that has been lacking in a lot of our floor debate this year. So I am really grateful to engage and have this conversation.
Thank you, Senator Slama. You are next in the queue.
Thank you, Madam President. Is this my third turn?
This is your third time.
Oh, fantastic. All right, so picking back up on the Crawford v. Marion County Election Board decision, I'm just reading from the syllabus now, and if we happen to have enough time, I'll hop back into the full opinions, but I just want to make sure that everybody gets the gist of these opinions because they're really helpful to understanding the constitutional limitations we have in place and where the Evnen Amendment really falls short and where I see it falling clearly short when it comes to the courts and enforcement with Nebraska's strict voter ID constitutional amendment language. Each of Indiana's asserted interests is unquestionably relevant to its interest in protecting the integrity and reliability of the electoral process. The first is the interest in deterring and detecting voter fraud. Indiana has a valid interest in participating in a nationwide effort to improve and modernize election procedures criticized as antiquated and inefficient. Indiana also claims a particular interest in preventing voter fraud in response to the problem of voter registration rolls with a large number of names of persons who are either deceased or who no longer live in Indiana. While the record contains no evidence that the fraud SEA 483 addresses, in-person voter impersonation at polling places has actually occurred in Indiana, such fraud has occurred in other parts of the country, and Indiana's own experience with voter fraud in a 2003 mayoral primary demonstrates a real risk that voter fraud could affect a close election's outcome. There is no question about the legitimacy or importance of a state's interest in counting only eligible voters' votes. Finally, Indiana's interest in protecting public confidence in elections, while closely related to its interest in preventing voter fraud, has independent significance because each such confidence encourages citizen participation in the democratic process. The relevant burdens here are those imposed on eligible voters who lack photo identification cards that comply with SEA 483. Because Indiana's cards are free, the inconvenience of going to the Bureau of Motor Vehicles, gathering required documents, and posing for a photograph does not qualify as a substantial burden on most voters' right to vote or represent a significant increase over the usual burdens of voting. Now, this is a really key sentence, so I'm going to repeat it again for the record. Because Indiana's cards are free, this is referencing the cards they use for those who didn't have a qualifying ID, the vote only cards that are accessible to the people of Indiana, the exact same as what we're imposing in my own amendment. The inconvenience of going to the Bureau of Motor Vehicles, gathering required documents, and posing for a photograph does not qualify as a substantial burden on most voters' right to vote or represent a significant increase over the usual burdens of voting. The severity of the somewhat heavier burden that may be placed on a limited number of persons, i.e. elderly persons born out of state who may have difficulty obtaining a birth certificate, is mitigated by the fact that eligible voters without photo identification may cast provisional ballots that will be counted if they execute the required affidavit at the circuit circuit court clerk's office. Even assuming that the burden may not be justified as to a few voters, that conclusion is by no means sufficient to establish the petitioner's right to relief that they seek. Petitioners bear a heavy burden of persuasion in seeking to invalidate SEA 483 in all its applications. This court's reasoning in Washington State Grange versus Washington State Republican Party applies with added force here. Petitioners argue that Indiana's interests do not justify the burden imposed on voters who cannot afford or obtain a birth certificate and who must make, thank you, Madam President, and who must make a second trip to the circuit court clerk's office, but it is not possible to quantify based on the evidence in the record either that burden's magnitude or the portion of the burden that is fully justified. A facial challenge must fail where the statute has a plainly legitimate sweep. And with that, I will mark my spot and continue with this case on my next turn on the mic. Thank you, Madam President.
Thank you, Senator Slama. Seeing no one else in the queue, you're recognized to close on your amendment.
My goodness, I've stunned everyone into silence. Well, thank you, Senator Dorn. I appreciate that. Back to Crawford versus Marion County Election Board. So if I am losing my voice today, it's not that I'm very much weak and losing it after a few hours of speaking. It's because I'm still very much recovering from my illness that took me out of the game at the end of the week last week, and my throat's not exactly healed up. So please bear with me if I get squeaky. When considering SEA 483's broad application to all Indiana voters, it imposes only a limited burden on voters' rights. The precise interests advanced by Indiana are therefore sufficient to defeat petitioner's facial challenge. Valid neutral justifications for a non-discriminatory law, such as SEA 483, should not be disregarded simply because partisan interests may have provided one motivation for the votes of individual legislators. Justice Scalia, joined by Justice Thomas and Justice Alito, was of the view that petitioner's premise that the voter identification law might have imposed a special burden on some voters is irrelevant. The law should be upheld because its overall burden is minimal and justified. A law respecting the right to vote should be evaluated under the approach in Burdick versus Takushi, which calls for application of a deferential, important regulatory interest standard for non-severe, non-discriminatory restrictions, reserving strict scrutiny for laws that severely restrict the right to vote. So that paragraph there is where I'm talking about when you're talking about voting rights. You've got two separate standards. You can either have strict scrutiny or you can have the important regulatory interest standards. So you've got two different ways in which you're working here. The different ways in which Indiana's law affects different voters are no more than different impacts of the single burden that the law uniformly imposes on all voters. To vote in person, everyone must have and present a photo identification that can be obtained for free. This is a generally applicable, non-discriminatory voting regulation. The law's universally applicable requirements are eminently reasonable because the burden of acquiring, possessing, and showing a free photo identification is not a significant increase over the usual voting burdens, and the state's stated interests are sufficient to sustain that minimal burden. Stevens J. announced the judgment of the court and delivered an opinion in which Robert C. J. and Justice Kennedy joined. Scalia filed an opinion concurring in the judgment in which Thomas and Alito joined, and that's posted later on in this opinion. Sauter filed the dissenting opinion in which Ginsburg joined. Breyer filed his own dissenting opinion. So that's the syllabus for Crawford versus Marion County Election Board. And I hope you were able to pick up on some of that. I will expand as I get more time on the mic. I've got another amendment coming up, but I am going to now withdraw this amendment and we'll put up the next one and reset.
You need a break for bathroom or otherwise.
Thank you, Senator Slama.
Take over wherever you're at.
The question is the adoption. The amendment is withdrawn, sorry. Mr. Clerk.
Madam President, Senator Slama would move to amend with FA 139.
Senator Slama, you're welcome to open on your floor amendment.
Thank you very much, and a big thank you to my wonderful administrative aide, Sue Ellen Stutzman, who is now handing me a can of my chosen carbonated beverage, which is called Liquid Death. The flavor is mango chainsaw, and it, quote, murders your thirst. It's really just a really stupid marketing thing that worked on me, but it is actually quite tasty. So at this point, I'm going to read through, and this is a very brief opinion, so I feel all right going into, it's a brief, but it's an important opinion because it is the Missouri case that is on point for my objections on Section 10 and Section 11. It's Priorities USA versus state. So here's the full text of the opinion. Sorry, just a second. Priorities USA, Mildred Gutierrez, Jaden Patrick, and West County Community Action Network filed a petition for declaratory and injunctive relief against the Missouri Secretary of State, alleging that Section 115427 unconstitutionally burdens individuals' right to vote. Specifically, they contend that prospective voters, because of their personal circumstances, will have difficulty adhering to Section 115427's photo identification requirements. This is helpful. After a bench trial, the circuit court entered a judgment finding Section 115427 constitutional except for subsections 2.1 and 3, the affidavit requirement. Subsection 2.1 permits individuals to vote with listed forms of non-photo identification if they execute an affidavit that meets certain requirements. The related subsection 3 provides the affidavit language. The circuit court enjoined the state from requiring individuals who vote under this option to execute the affidavit required under subsections 2.1 and 3. The circuit court also enjoined the state from disseminating materials indicating that photo identification is required to vote. The state appeals. Because the affidavit requirement of sections 11542721 and 115427.3 is misleading and contradictory, the circuit court's judgment declaring the affidavit requirement unconstitutional is affirmed. Further, the circuit court did not err in enjoining the state from requiring individuals who vote under the non-photo identification option provided in section 11542721 to execute the affidavit, or in enjoining the dissemination of materials indicating photo identification is required to vote. The circuit court's judgment is affirmed. Here's the section on background. Sorry, I had a tickle in my throat there. In 2016, the legislature truly agreed to and passed Section 115427, which became effective in 2017. Section 115427 establishes 3 options under which individuals can identify themselves for the purposes of voting. Again, this is the Supreme Court of Missouri ruling, very helpful to take from our sister states and our neighbors, especially when they're right across the river from my own district. Under the first option in subsection 1 of Section 115427, an individual can present acceptable forms of personal identification, all of which contain the individual's photograph. Under the second option, as found in subsection 2 of section 115427, an individual who does not possess the types of photo identification provided under the first option can vote by executing a statutorily specified affidavit and presenting a form of non-photo identification expressly authorized in section 11542721. The affidavit individuals are required to execute under the second option must be substantially in the form provided in section 115427.3. Individuals must aver that they are listed in the precinct register, do not possess personal identification approved for voting, are eligible to receive a Missouri non-driver's license free of charge, and are required to present a form of personal identification to vote. Finally, under the third option, individuals can cast a provisional ballot, which will be counted if, 1, the voter returns to the polling place during the polling hours and provides the approved form of photo identification under option 1, or the election authority compares the individual's signature with the signature reflected on the election authority's file and confirms the individual is eligible to vote at that particular polling place. Respondents filed a petition for declaratory and injunctive relief against the Secretary of State, alleging Section 115-427 unconstitutionally restricts the right to vote in Missouri by imposing burdens on prospective voters who, because of their personal circumstances, will have difficulty adhering to Section 115-427's identification requirements. After a bench trial, the Circuit Court entered a judgment finding Section 115-427 constitutional except for that affidavit requirement in subsections 2(1) and 3. The Circuit Court determined that the affidavit was contradictory and misleading and accordingly impermissibly infringed on an individual's right to vote. The Circuit Court enjoined the state from requiring individuals who vote under the second option to execute the affidavit required under subsections 2(1) and 3. The Circuit Court also enjoined the state from disseminating materials that indicated photo identification is required to vote. The state appeals. Standard of review. This court reviews de novo a challenge to the constitutionality of validity of a statute. That's based on the case Williams versus Mercy Clinics, Springfield Communities. A statute is presumed constitutional and will not be found unconstitutional unless it clearly and undoubtedly violates the Constitution. Nonetheless, if a statute conflicts with a constitutional provision or provisions, this court must hold the statute invalid. The party challenging the statute's constitutional validity bears the burden of proving a violation. The issuance of injunctive relief, along with the terms and provisions thereof, rests largely with the sound discretion of the trial court. The Circuit Court is vested with a broad discretionary power to shape and fashion relief to fit the particular facts, circumstances, and equities of the case before it. Analysis. 1. The affidavit requirement. The state argues the Circuit Court erred in enjoining the use of the affidavit when voting under option 2 because the affidavit requirement does not burden the right to vote and is constitutional. In response, respondents assert that affidavit requirement is misleading and contradictory and accordingly impinges on voters' right to equal protection and the fundamental right as guaranteed by the Missouri Constitution. The constitutional validity of the affidavit requirement. 2 constitutional provisions establish with unmistakable clarity that Missouri citizens have a fundamental right to vote. Article 1, Section 25 provides that all elections shall be free and open, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Article 8, Section 2 establishes the qualifications necessary to vote in Missouri. Missouri courts have made it clear that, pursuant to these provisions, the right to vote is fundamental. Further, the Missouri Constitution guarantees its citizens the equal protection of the laws. But, as the court has previously indicated, some regulation of the voting process is necessary to protect the right to vote itself. To determine the level of scrutiny that should be applied to evaluate a statute addressing that right to vote, Missouri courts first evaluate the extent of the burden imposed by the statute. And this is what was talked about in the syllabus of the last case, the Crawford decision. If a statute severely burdens the right to vote, strict scrutiny applies, which means the law will be upheld only if it is narrowly tailored to serve a compelling state interest. Conversely, when the law does not impose a heavy burden on the right to vote, it is subject to the less stringent rational basis review. So that's strict scrutiny versus rational basis. This court need not evaluate the extent of the burden imposed by the affidavit requirement because this requirement does not even satisfy even the rational basis review. The state asserts the affidavit requirement combats voter fraud through verifying a voter's identity and eligibility to vote. Such an interest is legitimate and even compelling. But to satisfy even the lowest level of scrutiny, rational basis review, the affidavit requirement must be rationally related to this interest. In other words, the requirement must be a reasonable way of accomplishing this goal. The affidavit requirement is set out in sections 115-427, 2(1), and 115-427-3. Subsection 2(1) provides that an individual who appears at a polling place, thank you, Madam President, without an approved form of photo identification under option 1, but who is otherwise qualified to vote, may cast a regular ballot provided the individual presents an approved form of non-photo identification as specified under option 2 in section 115, 42721, and executes an affidavit that meets certain requirements. Subsection 3 then provides that the affidavit must be substantially in the following form. And I'll pick up where I left off later. But again, I'm just going to take this for time and keep putting up amendments and withdrawing them before they come to a vote. So you don't need to worry about sticking around and missing votes. I've got you guys covered. But I really do want to get these cases on the record and get my concerns on the record and fully fleshed out so no one can say they didn't hear enough from me on voter ID. Thank you, Madam President.
Thank you, Senator Slama. Senator Raybould would announce that she had 41 fourth graders from McPhee Elementary in Lincoln in the balconies. They're no longer in with us right now, though, so then we'll go next to Senator Slama.
Sorry about that, Senator Raybould. I promise the next time school kids come in, I'll try to talk about something more exciting than voter ID case law. Although I think Senator Conrad and I might be the only two in this body that actually think that that's exciting. But yeah, back to the Missouri case that is exactly on point to my concerns with sections 10 and 11. When we're talking about the reasonable impediment language and how that's ambiguous and contradictory to potential voters. Here in the Missouri case, we're talking about that with their affidavit requirement and how differing instructions fail to even meet the rational basis level of review, which is the lowest bar that you can have. Subsection 3 then provides that the affidavit must be substantially in the following form. I do solemnly swear or affirm that my name is blank, that I reside at blank, that I am the person listed in the precinct register under this name and at this address, and that, under penalty of perjury, I do not possess a form of personal identification approved for voting. As a person who does not possess a form of personal identification approved for voting, I acknowledge that I am eligible to receive free charge a Missouri non-driver's license at any fee office if desiring it in order to vote. I furthermore acknowledge that I am required to present a form of personal identification as prescribed by law in order to vote. I understand that knowingly providing false information is a violation of law and subjects me to possible criminal prosecution. Section 115-427-3. Although this language is consistent with the requirements listed in subsection 2 also requires that individuals must aver they do not possess a form of identification approved under option 1 and must further acknowledge that they are required to present a form of identification approved under option 1 in order to vote. The affidavit requirements in section 115-427-21 and 115-427-3 is contradictory and misleading for several reasons. The affidavit language in subsection 3 requires individuals who vote under option 2 to aver that they do not possess a form of personal identification approved for voting. If form of personal identification means any identification, photo or non-photo, approved under section 115-427, then the affidavit is misleading because individuals voting under option 2 are required to swear under oath that they do not possess such identification, but then must present non-photo identification approved under section 2. But if consistent with the affidavit requirements in subsection 2.1, the phrase form of personal identification means only the photo identification approved under option 1. Then the later sentence in the affidavit that provides individuals must acknowledge that they are, quote, required to present a form of personal identification as prescribed by law in order to vote. See section 115-427-3. It's contradictory because individuals can vote by presenting non-photo identification as described in option 2. For this reason, the language of subsection 2, which provides that individuals signing the affidavit must acknowledge they are required to present a form of personal identification as described in subsection 1 of this section in order to vote, is inaccurate. Under either interpretation, an individual voting under option 2 is required to sign an ambiguous contradictory statement under oath and is subject to the penalty of perjury. So where this comes in, and I think it's really valuable to anchor this in something, where this comes in is the Ebnen Amendment's reasonable impediment language. A voter may genuinely believe, under penalty of perjury, that they have a reasonable impediment to them receiving a valid photo ID in order to vote. However, we run into the problem that the Secretary of State has set a floor and an ambiguous set of directions as to what qualifies as a reasonable impediment. So you've got a mix of different options as to what may or may not be acceptable as a reasonable impediment. That language is clearly ambiguous, potentially contradictory, and is lined up to confuse voters. And this is why this Missouri case from 2020 is so helpful and is so on point in understanding why the language of the reasonable impediment attestation just doesn't work. The testimony of several witnesses highlighted the confusion that resulted, thank you, Madam President, that resulted from the affidavit's contradiction. Gutierrez, who voted in November 2017 after signing the affidavit and presenting her Social Security card, voter identification card, and birth certificate, testified she found the affidavit's language concerning. By signing the affidavit, Gutierrez swore under penalty of perjury she did not possess a form of personal identification approved for voting when, in reality, she had all kinds of forms of identifications, end quote. The affidavit led her to believe that she needed photo identification to vote in future elections. I'm going to keep going with this on my next turn on the mic, which is probably. Thank you, Madam President.
Thank you, Senator Slama. Senator Lowe, you're recognized.
Thank you, Madam President. I just got up because I want to give Senator Slama a little break. Maybe she can sit down and relax for a minute. She's been up here speaking, and I appreciate that. She's a very good friend of mine, and so is Senator Brewer. So I really enjoy this debate that we're talking about today, because a lot of it is going over our heads, because it's attorney speak and it's being read from court documents and things like that. But I'm on the Government, Military, and Veterans Affairs Committee, and this was the bill, the amendment that we kicked out was what went into 853. We kind of had an understanding that this was the right thing to do. As we looked at the amendments, we had 3 amendments before us, and we kind of went through all 3 amendments, and we kind of pieced them together, and we wanted one to come out that wasn't going to take too much debate and we could get passed. We looked at Senator Slama's amendment, and I told her that day, I said, I'd really like this attached onto your bill, because you're the one that really pushed through voter ID. You got the referendum on the ballot, and it got voted on by the people of Nebraska, and it won handsomely. So the people do want voter ID. I want voter ID. I want it through, and I don't want it contested. I know it's going to be contested no matter which way we go, but I want the people to win out of this deal. I have my constituents from both sides of the platform, and they're all emailing me saying, vote this way or vote that way. Well, I got elected by a majority vote, and I'll probably vote that way because that's the way they wanted me to vote when I came down here. I spoke my views, and the majority agreed with me. I've listened to some of the debates, and I've voted on some bills I didn't really agree with, but I didn't think they'd do much harm. And that's kind of what I want this end product to do, is do as little harm as possible, especially to those in the nursing homes and assisted living homes and those just not able to get out of their house. We need to make sure that they're all able to vote because they're citizens. And we need to make it so that they can vote. I don't like a lot of mail-in voting, but it's something we need to do for these people. I think that we need to limit mail-in voting. I don't think we need to do it for a full month, but maybe a week we could do that. And for special needs only, for people like this, people in the military, people that just can't be there that day. I don't want it to be a laziness deal that I just don't want to go down and vote in person. I think that takes something from us when we don't want to do things in person. It's good to stand up. It's good to go down there. It's good to get that sticker on your jacket when you leave from there. It's good to be proud and to vote in person. I think that's very important. If Senator Slama's had a long enough rest now, I'll stop babbling along, and I appreciate her making a stand for what she truly believes in, and that I wish I could stand with her on this. But with that, thank you, Madam President.
Thank you, Senator Lowe. Senator Slama, you're recognized.
Thank you very much, Senator Lowe. I appreciate your thoughtful approach to this process and also your efforts to try to keep this as being attached to my bill, which I really do appreciate. As leading the voter ID petition drive, it really would have been great to be able to see my own bill get across the finish line. But that didn't happen, and I'm okay with that. I'm at peace with that. But now I'm just going to fight and do everything I can to make sure the will of the people is heard and that we're adhering to the constitutional amendment that so many people fought so hard to get across the finish line. Senator Lowe is one of my really good friends in this body. I'm even better friends with his wife, Kim Lowe. I think she's in town today, and I might swing by and visit her during supper time, so long as I can get food quick enough. But I really do appreciate Senator Lowe's ability to give me a break. The problem is his voice is just so soothing. I was like halfway asleep during it, which is just a really impressive talent that I don't have. Apparently every time I get up on the mic, I sound very highly strung. I've tried to deal with that, but I will never be soothing on the same level as Senator Lowe. If he could filibuster every bill, or if we could all filibuster bills at that same level, I'm pretty sure we would be a much more level-headed and soothed body. But in any case, we don't have that. So we're stuck with what we've got, and what you've got is me. And we're on the Priorities USA versus State Supreme Court of Missouri ruling, which is really helpful in understanding why the reasonable impediment language used in the Evnen Amendment is not constitutional and will fail to meet even the rational basis test standard that the affidavit standard failed in Missouri in this 2020 case. So back to the opinion language. Similarly, Patrick, who voted in November 2017 election by presenting their voter identification card and signing the affidavit, testified the language of the affidavit was confusing and ambiguous because it required them to state they do not possess personal identification when they, in fact, did have their personal identification card, their voter identification card. Both Gutierrez and Patrick testified they would not sign the affidavit to vote in a future election. The record further indicates that election officials did not understand the affidavit requirement. For example, Gutierrez was informed by an election official that she would need to obtain photo identification to vote in the next election. And one of respondents' witnesses, David King, was told he could not vote despite presenting his voter registration card, an acceptable form of non-photo identification under option 2. This is under section 115-42721. Although the state had an interest in combating voter fraud, requiring individuals voting under option 2 to sign a contradictory and misleading affidavit is not a reasonable means to accomplish that goal. For this reason, the affidavit requirement of sections 115-42721 and 115-427.3 does not pass muster under any level of scrutiny. Accordingly, the circuit court's judgment declaring the affidavit requirement unconstitutional is affirmed. Just a second. B, the remedy. After declaring the affidavit requirement unconstitutional, the circuit court enjoined the state from requiring voters who cast a ballot under option 2 to execute the affidavit. The state argues the circuit court erred in severing the affidavit requirement in its entirety. According to statute, 2 alternative narrower remedies existed. First, the state argues the circuit court could have allowed the Secretary of State to rewrite the affidavit language.
1 minute.
Thank you, Madam President. In the alternative, the state argues the circuit court could have severed only the parts of the affidavit requirement the circuit court found unconstitutional. One, revision by the Secretary of State. Section 115-4273 provides that the affidavit's language must be substantially in the form provided by the statute, implying the form in section 115-4273 need not be followed exactly. The state argues the circuit court should have followed the Secretary of State to modify the affidavit's language to address the circuit court's constitutional concerns. This proposed remedy falls short of rectifying the affidavit requirement's constitutional flaw. Although the affidavit need only be substantially in the following form provided in section 115-4273, any modification must be consistent with the affidavit requirements in section 115-4721, which the Secretary of State has no authority to alter. I'll pick up there on my next turn on the mic. Thank you, Madam President.
Thank you, Senator Slama. Senator Dorn, you're recognized.
Question. Okay. Thank you, Madam President. Thank you very much. Wanted to know if Senator Slama would yield to some questions.
Senator Slama, will you yield?
Yes, I will.
As well. Well, part of, through all this process today, I've been getting numerous emails about some questions or some of the process here going on. And one of them that I thought was a little interesting, as we sign up, as we show our voter ID, whether we vote once or whether we do it at the county election place or wherever, are we then done? Do we not have to ever show it again? Or do we, every time there's an election, every time even there's a mail-in ballot, we're going to have to go through this same process?
Yep. So that's a great question and really helpful since we're talking about the religious exemption language, which I argue should be the opposite of that. But with the language of the constitutional amendment, you would be required to show an ID every single time you voted.
Every time we vote, and then
Yes.
Even the mail-in ballots now, this process, there's been several different types that we've talked about today. That would also be the same way with a mail-in ballot. You're not just signed up once. You will go through this process numerous times, and every time you go to the ballot box.
Yep. Under either approach, whether you're looking at the Evnen Amendment or my amendment, you would have to go through that every time you vote.
Every time. Okay, good. Thank you for answering that.
Thank you.
Then the other one is, and it's as much my, I guess, question as much. I visited with Senator Conrad earlier today, talking about the special election. What are we looking at there? How will we get to that point, or will we get to that point? Is there something that this will be going through? I call it the court into Nebraska Supreme Court. Is this just an Attorney General's opinion, or what is the process that might get us to that point?
Yep. So I love that question, and I appreciate getting the chance to clarify. Senator Conrad did make a very fair point in that a special session doesn't just appear out of thin air. The voters have dictated to us that we need to designate a framework for voter ID in the session. If you remember from our freshman biennium, when we legalized gambling, it was the same idea in that we were obligated by the voters through that constitutional amendment to pass a framework to legalize gambling in that session. If we fail to fulfill those constitutional obligations, it's my interpretation that we would be called, and my understanding from a few different sources, that a special session would occur. Moreover, if the court decides to throw out the bill that we pass, we'd be stuck in the same position. So stuck not fulfilling our duty to the voters to fulfill that language of the constitutional amendment.
Okay, but one of my questions was with expanded Medicaid, that I call it went on for a period of time.
It did.
Why then can't this go on for a period of time? Why does it have to be, I call it, done in time for the next election?
Yep, this one's a very clear cut, ready to go one where there's no real question about how it should be, about whether it should be implemented. There's no question that we have to fulfill that constitutional amendment language. With the Medicaid expansion, I believe there was a back and forth about the requirements presented by that language.
There was a federal, I forget the number, there was a federal number that there was in question whether or not that applied or not, and all those things with that. So, no, so the people in Nebraska, there's a real good probability that the next time they go to vote, which would be in the spring of 24, fall of 24, that they will have voter ID in place.
Yes, that is absolutely my goal.
1 minute.
And I'm hopeful everybody's goal that's involved that we have this in place for the 24 elections.
Thank you for answering those questions.
Thank you.
Thank you, Senator Slama and Dorn. Senator Slama, you've already had your third time, and so this will be your close. No one else is in the queue.
Thank you very much, and I'm absolutely not tracking this. But I do appreciate Senator Dorn's questions. And if you have any questions about any part of voter ID or the different approaches we took, please ask questions. Like, please ask questions of me. I think Senator Conrad is still on the floor and would be happy to answer questions from her perspective too. Like, we love nothing more than nerding out on this issue, and we can have a constructive dialogue back and forth about it.
I don't like
And really build that legislative record for the two differing approaches that I think we have here. One is a very much less restrictive voter ID that I would argue is voter ID without voter ID. And on the other hand, you have my own approach, which is a more conservative approach to voter ID that takes the lessons we've learned from different cases, some of which I'm taking the chance to read through now, to really build an amendment that is constitutional and it's workable. I'm happy to work with anyone, and all I need is a commitment. Like, if somebody who is empowered to do so gets on the mic and says, I agree to work with you between general and select to help address your concerns with the constitutionality of this bill, like, that's literally all it'll take, and I will sit down and we will get back on to the next thing on the agenda. Like, that's the thing I'm going for here. I've outlined my 3 asks. I've outlined my constitutional issues with this bill. And now I'm going into the case law that I believe is very helpful in helping us understand the issues that I've raised on the constitutionality of the Evan Amendment. So I appreciate this conversation. I'm willing to hop out at any time if somebody gets on the mic and gets on the record and say, I'm willing to work with you to address these concerns. And with that, I'd like to withdraw my floor amendment and we'll head on to the next one.
Thank you, Senator Slama. It is withdrawn. Items for the record, Mr. Clerk.
Thank you, Madam President. Communication from the governor. Engrossed Legislative Bill 574E was received in my office May 22nd. This bill was signed and delivered to the Secretary of State on May 22nd, 2023. Sincerely, Jim Pillen, Governor. Additional communication. Engrossed Legislative Bill 799E, 799AE, 813E, 815E, 816E, and 282E were received in my office on May 17th, 2023. These bills were signed and delivered to the Secretary of State on May 22nd, 2023. Signed sincerely, Jim Pillen, Governor. New LR 253 from Senator McDonald. That will be laid over. Additionally, motion to be printed from Senator Kavanaugh to LB 514. Madam President, Senator Slama would move to amend with FA 146.
Senator Slama, you're recognized to open on your amendment.
Outstanding. Thank you very much, Madam President, and good afternoon again, colleagues. We're solid 2 hours away from our dinner break. If you need to go run errands, it's fine. I've got the floor here, and unless you want to hop in and get involved, you're always more than welcome to. But I won't be bringing any of these to a vote because I do respect the process. I really just want to build the legislative record with my concerns. I think I pretty well outlined those on the last turn on the mic, so I will return back to the Priorities USA versus State, which is a case directly on point from the Supreme Court of Missouri from 2020. So back to Section 1, subsection B, sub 1, revision by the Secretary of State. Pursuant to Section 115-42721, the affidavit must include language acknowledging that the individual is required to present a form of personal identification as described in subsection 1 of this section in order to vote. As emphasized above, such a statement is misleading as option 1, photo identification, is not required to vote. Accordingly, because any modification by the Secretary of State must follow the requirements in Section 115-42721 and include this misleading statement, allowing the Secretary of State to rewrite the affidavit's language is not an adequate remedy. The affidavit's severability, sub 2. In the alternative, the state asserts the Civil Circuit Court should not have enjoined the affidavit requirement entirely, but instead should have severed only the portions of the text it found unconstitutional. While the provisions of every statute are severable, when a portion of a statute is found unconstitutional, the remaining provisions will not be upheld if they so essentially and inseparably connected with and are so dependent upon the void provision that it cannot be presumed the legislature would have enacted the valid provision without the void one. This court employs a two-part test to determine whether valid parts of a statute can be upheld despite the statute's unconstitutional parts. First, this court considers whether, after separating the invalid portions, the remaining portions are in all respects complete and susceptible of constitutional enforcement. Then this court considers whether the remaining statute is one that the legislature would have enacted if it had known that the rescinded portion was invalid. As established above, the phrase form of personal identification as used in sections 115-42721 and 115-427.3 is misleading and contradictory. For this reason, the portion of the affidavit requiring individuals to aver they do not possess a form of personal identification approved for voting, and the portion of the affidavit requiring individuals to acknowledge they, quote, are required to present a form of personal identification as prescribed by law in order to vote, as well as the corresponding language in section 115-42721 are unconstitutional. Under either interpretation of the meaning of form of personal identification, an individual voting under option 2 is required to sign an ambiguous contradictory statement under oath and subject to the penalty of perjury. After this language is severed, the affidavit language in section 115-427.3 reads in pertinent part, I do solemnly swear or affirm that my name is blank, that I reside at blank, that I am the person listed in the precinct register under this name and at this address, and that under penalty of perjury, I do not possess a form of personal identification approved for voting. As a person who does not possess a form of personal identification approved for voting, I acknowledge that I am eligible to receive free of charge a Missouri non-driver's license at any fee office if desiring it in order to vote. I furthermore acknowledge that I am required to present a form of personal identification as prescribed by law in order to vote. I understand that knowingly providing false information is a violation of law and subjects me to possible criminal persecution. The portion of the affidavit language providing, I acknowledge that I am eligible to receive free of charge a Missouri non-driver's license at any fee office if desiring it in order to vote, as well as this corresponding clause in subsection 2.1 would also need to be severed to avoid a misstatement of the law. As the Secretary of State's witness testified that not everyone is eligible for a free non-driver's license. While removing this language eliminates any constitutional concerns, requiring individuals to sign this modified version of the affidavit would be futile, as all voters are required to sign a precinct register establishing the voter's identity and qualification to vote. The precinct register further provides notice that, quote, it is against the law for anyone to vote or attempt to vote without having a lawful right to vote. Because the modified version of the affidavit would essentially replicate the information in the precinct register that every voter must sign, the legislature would not have enacted the modified affidavit. Although the dissenting opinion does not reject this court's holding that the affidavit requirement of sections 115-427.21 and 115-427.3 is misleading, contradictory, and unconstitutional, the dissenting opinion agrees with this court's decision to affirm the circuit court's severance of the affidavit requirement. The dissenting opinion presents two alternative remedies it believes should have been adopted instead. For the reasons below, both remedies are nonsensical. First, the dissenting opinion suggests that the circuit court should have severed sections 115-427.2 in its entirety rather than severing only the affidavit requirement language. As the dissenting opinion notes, if option 2, the non-photo identification option, is severed, two options for voting remain, option 1 and option 3. Under option 1, an individual cannot vote without showing a government-issued photo identification. Under option 3, an individual's vote will not be counted unless the voter returns to the polling place during the polling hours and provides an approved form of photo identification under option 1, or 2, the election authority compares the individual's signature with the signature on the election authority's file and confirms the individual is eligible to vote at that particular polling place. The record reflects the signature matching process could result in an over-rejection of legitimate signatures, as there is no training or uniform standards election officials follow. So regardless of whether individuals vote pursuant to option 1 or option 3, to ensure their votes are counted, individuals must show a photo identification. In effect, the dissenting opinion's proposal to sever option 2 in its entirety would result in individuals having to present government-issued photo identification to ensure their votes are counted. In one check, this court made clear that requiring individuals to present photo identification to vote is unconstitutional. And this is just for the transcribers. Wincheck is spelled Weinschenk. Wincheck emphasized that some individuals, due to their personal circumstances, experience hurdles when attempting to obtain photo identification, a concern that remains relevant in the instant case. Obtaining photo identification requires appropriate documentation, time, and the ability to navigate bureaucracies. Quote, those things that require substantial planning in advance of an election to preserve the right to vote can tend to eliminate from the franchise a substantial number of voters who did not plan so far ahead, end quote. This quoting Harmon versus Forsenius. Harmon spelled Harman, and Forsenius is spelled Forssenius. For these reasons, the dissenting opinion's first proposed remedy possesses constitutional concerns and could not have been adopted by this court. Second, the dissenting opinion proposes the circuit court could have severed only the contradictory affidavit language, but maintained the affidavit requirement for non-photo identification voting. Notably, the dissenting opinion is not specific regarding which part of the affidavit's language it could have severed. Regardless, as made clear above, after the unconstitutional provisions are severed, the modified version of the affidavit would essentially replicate the information in the precinct register that every voter must sign. Accordingly, the legislature would not have enacted the modified affidavit. For these reasons, the dissenting opinion's proposed remedies are nonsensical, and the circuit court did not err in enjoining the affidavit requirements in its entirety. Section 2, the Secretary of State's
1 minute.
materials. Thank you, Madam President. I'm going to tab off there and just repeat for the good of the cause as I turn my light back on for next time. That I am happy, more than happy, in fact, to stand down if I get a commitment from either the Speaker or the Chairman of the Government Committee that we will work on and work to address these concerns between general and select. But until I get that commitment, I'm going to keep fighting for the voters in Nebraska who overwhelmingly approved a strict photo ID, voter ID requirement. So I'm here for the full 8 hours. If you have any questions to ask me, please feel free. I'm happy to answer them. But otherwise, I'm going to keep reading this case because it is extremely helpful. It's a really easy to read case that really dives into the meat of the problems with the reasonable impediment language and how that language will absolutely not hold up if it gets challenged in Nebraska court. Thank you, Madam President.
Thank you, Senator Slama, and you're next in the queue.
Oh, happy day. Well, we can pick up directly where we left off. Section 2, the Secretary of State's materials. Again, this is Priorities USA versus State, decided in the Supreme Court of Missouri in 2020. I'm referencing it in relation to the reasonable impediment language offered in the Evening Amendment and why it will not hold up because it is contradictory and ambiguous, as court determined was unconstitutional and failed a rational basis test in a similar affidavit language utilized by Missouri, and that was thrown out by the state Supreme Court. The Secretary of State's materials. The circuit court also enjoined the state from disseminating, quote, materials with the graphic that voters will be asked to show a photo identification card without specifying other forms of identification which voters may also show. The state argues the circuit court erred in enjoining the Secretary of State from disseminating such materials because these materials accurately reflect Section 115.427's requirements. Section 115.427.5 assigns the Secretary of State the duty to notify the public of the personal identification requirements of Sections 115.427. Section 115.427.5 provides The Secretary of State shall provide advance notice of the personal identification requirements of subsection 1 of this section in a manner calculated to inform the public generally of the requirement for forms of personal identification as provided in this section. Such advance notice shall include, at a minimum, the use of advertisements and public service announcements in print, broadcast, television, radio, and cable television media, as well as posting of information on the opening pages of the official state internet websites of the Secretary of State and Governor. The advertisement promulgated by the Secretary of State that the Circuit Court found problematic provided voters, Missouri's new voter ID law is now in effect. When you vote, you will be asked for a photo ID. A Missouri driver or non-driver license works, but there are other options too. If you don't have a photo ID to vote, call 866-868-3245 and we can help. As the Circuit Court determined, materials like this advertisement mislead individuals into believing photo identification is required to vote. This finding is supported by the record as respondent's political science expert, Dr. Kenneth Mayer, that's Mayer spelled M-A-Y-E-R, testified that materials that are incomplete and fail to describe all of the forms of identification permitted in 115-427 cause confusion and decrease voter turnout. The state asserts the advertisement is an accurate statement of section 115-427 because when individuals vote, they're asked to show photo identification, but no part of section 115-427 mandates that election officials ask individuals for photo identification. Indeed, at trial, the state asserted that while election officials may request photo identification, they are not required to, as all three methods of voting are equally valid. The advertisement misleads individuals into believing photo identification is required to vote, which is an inaccurate characterization of section 115-427. After finding the advertisement misleading, the Circuit Court had discretion to, quote, shape and fashion relief to fit the particular facts, circumstances, and equities of the case before it. The injunction was limited in scope as it enjoined the state from disseminating only those materials with a graphic that voters will be asked to show a photo identification card without specifying other forms of identification, which voters may also show. The decision to enjoin these materials is well supported in the record. The Circuit Court did not. Thank you, Madam President. The Circuit Court did not abuse its discretion in enjoining the Secretary of State from disseminating materials that provide a misleading description of section 115-427's requirements. Conclusion, I will get to that on my next turn on the mic. But again, I'm not doing this for vanity. I'm not doing this for fun. I'm not doing this because I like to hear myself talk, which like most people, when I hear my own voice, I don't like my own voice. This is literally just because I have worked on voter ID for years. I've worked on it for years, and I'm telling you my core objections to the Evident Amendment, which has been adopted as a Government Committee amendment. I have all the respect in the world for the Government Committee, but unfortunately, they're taking some advice that I do not agree with, and I'm going to take my time outlining why until someone gets on the mic and says that they're willing to work with me and address these constitutional issues between general and select. Until that happens, I'm going to take
Senator.
time. Thank you, Madam President.
Thank you, Senator Slama. Senator Bosselman would like to recognize a very special guest. His wife, Jan from Brainerd, is sitting underneath the south balcony. Please rise and be recognized by your Nebraska Legislature. Senator Clements, you're recognized.
Thank you, Madam President. I received the notebook and I was looking at it, and the mail-in voting is an item that I was really hoping that we can make more secure in the election or voting bill. And I would ask if Senator Slama would yield to a question.
Senator Slama, will you yield?
Yes, although now that the budget's passed, I'm less likely to.
Thank you, Senator Slama. I was looking at the flow chart on mail-in voting. And first of all, is that a chart of how your bill would work or the committee amendment?
Yes, this is a chart of how my own bill would work.
Yours would. And does your proposal allow for mailing out ballot applications to voters?
So it doesn't address that. It more addresses it on turn-in. That's where we really wanted to attack and ensure security of our mail-in voting process.
My understanding is there are some counties that do 100% mail-in balloting. Was that be permitted under your proposal?
Absolutely, yes.
All right. And so in that case, people wouldn't have to provide a valid reason in their written request. But when there isn't 100% mail-in voting, is there a valid reason needed on requesting a early ballot?
We don't change our no excuse requirement for mail-in voting. So no, we're not changing that.
All right. Then on the, they have a voter, is the voter on the signature photo ID list? That's a term I'm not that familiar with. What is the signature photo ID list?
Yes, that is somebody who would fall outside of the standard voter ID registration list. Somebody who does not have a valid voter ID. For example, somebody who has a sincerely held belief against being photographed. If they do have that sincerely held religious belief, they would simply sign their ballot envelope. No witness requirement is necessary. But if they don't fall into the bucket of people on the signature photo ID list who has a religious objection, then that voter would have their ballot envelope witnessed or notarized after providing the certificate with the picture that was issued by the Secretary of State. So that second bucket, first one's religious objection to being photographed. The second bucket is this person has literally no way of obtaining a birth certificate or any documentation after reasonable investigation by the Secretary of State's office to obtain the documents necessary to get one of those free voting IDs. That's a relief valve that you have to have included. And that group of people would receive that photo ID-ish that's provided by the Secretary of State that has their name, confirms they're a voter, and has their picture on it. That way they are still providing a photo ID. So that is two separate buckets.
Back to the first part, the signature photo ID list. So if I have a driver's license has my signature on it, that means that I am on the signature photo ID list?
No, if you're on the signature photo ID list, you either have a religious objection. Thank you, Madam President. You either have a religious objection to being photographed, or you fall into that very rare case.
Okay, so this is a narrow, just a small group of people we're talking about.
Extremely narrow, probably around 5.
In either case, it's going to require a witness on the ballot envelope, right?
Yes, sir. Witness or notary.
Thank you.
Yes.
Thank you, Madam President.
Thank you, Senator Slemons and Senator Slama. Senator Erdman would like to recognize two guests sitting under the south balcony, Tony and Tracy Tangwall from Chadron, Nebraska. Please stand and be recognized by your Nebraska Legislature. Senator Slama, you're next in the queue.
Thank you very much, Madam President. Let me clear off my binders here. I do appreciate the questions from Senator Clements about the mail-in voting process. I know the signature photo ID list can be confusing by name. If you want to have it be a different name, I'm more than happy. If we want to have it be the wonderful chairman of appropriations, Rob Clements ID list, that would work with me. I'm not sure what the restrictions would be on names, but I'm happy to work with you there. But I just want to get back to the conclusion before I wrap up. This might be my last turn on the mic. Is this my last turn on the mic, Madam President? Oh, thank you. Can I just take a moment? Our pages are wonderful. Like, they've just gotten through their semester finals and are now diving headfirst into summer break, and they're still here with us on late night debates. God bless them. They are wonderful humans, and I wish them nothing but the best in the future. And if they ever need a letter of rec, they can always reach out to me. But yeah, back to the conclusion from the Priorities USA versus State Supreme Court of Missouri case from 2020, which I believe is directly on point as it references the language used in the reasonable impediment language of the Evnen Amendment, in that it is contradictory and ambiguous in violation of the threshold, the rational basis threshold that the court clearly establishes is applicable under Missouri's affidavit language. But back to the conclusion of this case, and then I'll go into a little bit more detail and reset where we're at and where we're headed. In conclusion, because the affidavit requirement of sections 115-427-21 and 115-427-3 is misleading and contradictory, the circuit court's judgment declaring the affidavit requirement unconstitutional is affirmed. Further, the circuit court did not err in enjoining the state from requiring individuals who vote under the non-photo identification option provided in section 115-427-21 to execute the affidavit, or in enjoining it from disseminating materials indicating photo identification is required to vote. The circuit court's judgment is affirmed. Now, this ruling is especially helpful for a few reasons. One, it's one of the very rare opinions we get that's really bite-sized, and you can take away clear things from this decision that are extremely helpful in how we're looking at the Nebraska voter ID language. Now, where this applies to the Nebraska voter ID language is the reasonable impediment language. So if a voter comes in and they think they have a reasonable impediment to voting, and they say they do, they believe they do, they can be under the impression that they do, but when they get the sheet, they see that of the three options determined by the Secretary of State's office to be a reasonable impediment, they do not qualify. So you're asking someone to conform their reasonable impediment to three different forms on a sheet. So you run into the problem of a person who, in using this reasonable impediment language, which is why it's so problematic and why it just shouldn't even be used in this amendment language, who's left either forcing themselves into a box that they don't qualify for, committing perjury, as we outlined was a problem in the Missouri case, or walking away believing they have a reasonable impediment but being unable to vote, essentially disenfranchising that voter. That's why this reasonable impediment language is so problematic when we're talking about the Evnen Amendment, not only in practice, but because we have a Supreme Court of Missouri case that's exactly on point. We need to learn. I mean, voter ID is one of the most litigated issues in the country. 35 states have it, and I'm pretty sure all 35 states, when going through the implementation of voter ID, ended up with a lawsuit on either side. Thank you, Madam President. It's like third to abortion and gun rights when it comes to amounts of litigation. And we have the lessons from other states. If we fail to learn the lessons of other states and we're left here holding a bag of an unconstitutional amendment, that's on us. So I'm grateful for everybody who's stuck around and who's listening. I believe I have my close up next, so I'll just hold my other thoughts for that. Thank you, Madam President.
Thank you, Senator Slama. Senator Conrad, you're recognized.
Thank you, Madam President. And I wanted to give my friend Senator Slama a chance to use the facilities and confer with her staff. And in response to Senator Clement's questions, I thought perhaps it might be an appropriate time to provide just a little bit of clarity in terms of some of the mechanics or some of the terminology relevant to this debate as well. Let me start with a quick story at first, though, since we have some time, and want to make sure Senator Slama has the time that she needs, even though she's doing a great job of making the case from her perspective. There's so many special memories I have in this beautiful building, in this beautiful space, and many of you know that I got that political spark very early in life when I was in elementary school, and I had an opportunity not only to volunteer on Helen Busalis's gubernatorial campaign, but after that formative experience, I had a chance to join then Governor Orr and a host of election officials, along with my grandparents and my parents, here at the governor's hearing room to do I believe it was a vote by mail press conference to encourage more people to vote. And I was in elementary school, and it was such an exciting time to be able to be with the Governor Orr and so many incredible leaders in the state. And I remember my mom bought me a new dress, and she even made me a sash like you see in beauty pageants. It was a blue sash, like on satin material with white lettering that said 1996 voter on it. And I loved that sash and proudly wore it to the press conference and still have it in my keepsake book at home. And so it's kind of a fun full circle moment to be back in the Capitol as a state senator, still working to advance voting rights as I had a chance to be inspired to do as a young person in this very building. But one thing that I wanted to make clear, and I think we hear about this a lot at the government committee, and it definitely causes confusion for citizens and other stakeholders as well, is just about some of this terminology and some of these mechanics. So you might remember, and we've talked about it already today, I think it's about 11 counties in Nebraska that are all vote by mail counties. So Senator Clements asked a great question about process and procedure. So in these counties, you don't get a vote by mail application, you get a ballot. All registered voters get a ballot. There isn't a vote by mail application process. So that's the first piece. Other counties do it different ways, do it a little bit differently. So Lancaster County, for example, I believe Douglas as well, has utilized a permanent vote by mail list or registry where citizens step forward and they'd say, it's my preference to vote by mail, and I'd like to do so in future elections. So for the folks that are utilizing a permanent vote by mail list, what the election commissioner in those counties might do, or does do actually, is then they automatically send out a vote by mail application to everybody on that VBM list, that vote by mail list. And then you have the obligation to return it and request your early ballot. That's how it works in Lancaster and Douglas County generally. And then in other counties, it's on an individual basis that citizens have to request their, thank you, Madam President, have to request their early ballot. So one thing that I think is frequently confusing about how this works from a mechanics perspective, or that causes unfounded concerns about fraud, is that as the popularity of vote by mail increases, and it has year over year over year over year, including huge spikes during the pandemic, and then we continue to see growth in that type of voting for a lot of different reasons. But as we see more people embrace vote by mail, more candidates and more interest groups are also trying to facilitate voting rights through vote by mail. So what you will see is that candidate campaigns and interest groups or partisan groups or civic groups will send out vote by mail applications to registered voters. And vote by mail applications are not the same as ballots, but that's frequently some of the confusion.
Time, Senator.
Thank you,
But you're
Madam
next to the
President.
queue.
Thank you, Madam President. So that's frequently some of the confusion that we might hear from the citizenry, or that we have heard about at the government committee, when people bring up the concerns that, oh my gosh, so-and-so, my neighbor or so-and-so that I heard about in my community received 4 or 5 ballots. They're typically not receiving multiple ballots. They're typically receiving multiple vote by mail applications. And sometimes the lists utilized by candidate campaigns or partisan groups or civic groups aren't always as up to date in terms of the voter rolls that are in place for our election officials. So sometimes you will see them being mailed in error to maybe folks that moved, or maybe folks who had passed away since the last election. And there's a key and important distinction between vote by mail applications and actual ballots. But I think that has definitely caused a lot of confusion for stakeholders. The other thing that I think is important to keep in mind, and we hear a lot about this at the government committee, and I know my friend Senator Lowe listens attentively to those who come before the committee. He's a very diligent committee member, but we know that different people utilize vote by mail for all different reasons. Some geography, like we have in those rural counties where everybody automatically gets a ballot. Sometimes people are traveling. Sometimes people have illness. Sometimes people don't know where they'll be on election day or have to work on election day and can't get off, even though there are some provisions to get time off on election day. But a lot of times people also want to do their due diligence and sit down with a cup of coffee, sit down with their computer, for example, and really take time to read the League of Women Voters Voter Guide or the Journal Stars, or to do their own independent research about the lengthy ballot initiatives, or particularly lower ballot races that may not receive as much information or as much attention. And so we definitely can see that there's been a long-standing tradition in Nebraska to utilize vote by mail and no excuses absentee voting. We were an early adopter in that regard. We've continued to see more and more Nebraskans, for different reasons, embrace other opportunities to vote by mail year over year over year, cycle after cycle. But I think it's cool that we also maintain an option for people to be able to vote in person if that is their preferred course of voting. I think it definitely brings a lot of gravity to the moment and a lot of formality, and it can be a really important civic opportunity to check in with other members of your community and your friends and neighbors as well. So we have all of these different processes in place. Oh, and I forgot to mention that sometimes for special elections like school bonds, we also see every registered voter getting a ballot instead of a vote by mail application. So we've got all of these different processes and procedures in place for different counties, for different elections, for different types of elections, based on individual voter preferences, discretion that is afforded to individual county election officials. And that being said, it helps to ensure that we're doing what Secretary of Ebnen has talked about in the past. We're making it hard to cheat, but easy to vote. And I always thought, well, maybe there is something to that saying, because I think it encapsulates what we're all talking about and what we're all concerned about.
1 minute.
Thank you, Madam President. We want to ensure that folks that are ineligible to vote do not have an opportunity to vote. We want to make sure that folks who are eligible to vote do not face unnecessary burdens in that regard. So what I think the government committee amendment does is it helps to advance those North Star policy goals. We know that there's existing law in place in regards to how we handle citizenship issues, fraud issues. Those are well vetted, well documented, and come with significant criminal penalties, as they should. When it comes to ensuring that we facilitate the will of the people to implement voter ID, it's not going to be a problem for a lot of folks, but for some of the folks, for a variety of different reasons, who might not otherwise be able to cast a vote, even if they are eligible, we have to have some fail-safe, some safe harbor for them, so we don't turn away eligible members of our democracy. Thank you, Madam President.
Thank you, Senator Conrad. Senator Blood, you're recognized.
Thank you, Mr. President. Fellow Senators, friends all, I stand opposed to the floor amendment, but in support of the government's amendment and the underlying bill. And with that, I would ask that Senator Brewer yield to a quick question.
Senator Brewer, would you yield?
Yes.
Senator Brewer, during this debate, really the only communications I've received, except for a few random emails from other districts, is one in reference to domestic violence victims. And I was hoping we could just go ahead and get it on the mic so they can hear it during debate. Are you okay with that? In reference to ID, I know you know the answer to this.
Okay. Well,
Or I wouldn't ask you.
I'm glad you know that I know.
I have hope, Senator. So I'm just going to read what they wrote to me. Abusers use many different types of control over their victims, and one of those is confiscating the state-issued IDs, birth certificates, and social security cards of their victims, which we know. They do whatever they can to make sure that people can't leave the situation. And so lots of times victims will find themselves homeless or in a shelter, sometimes couch surfing without any type of legal ID or any way to replace it. How are they able to remedy this through the bill that we're presenting?
Well, that was one of the issues that we had to figure out an option with. And so the idea was that they could still vote, that there would be a time given post-voting, that they would then be allowed to go through a process to establish their criteria for eligibility, and that would then suffice for the need for that ID that they didn't have at the moment that they were actually going to vote.
So they could ask for an exception?
Yes.
Basically.
I'm sorry.
All right. See, I knew you'd know the answer, Senator.
Well, I was trying to walk you through the thought process.
I appreciate that. And I think it's important when people watch this and we start seeing panicked advocates concerned about the people that they serve, that it's okay for us to have this conversation and just make sure that they know that you are indeed aware of this issue. I think you actually had people come and testify about it during the hearing, if I remember correctly. All right. Thank you, Senator Brewer. With that, I would yield any time if I have any left to Senator Slama.
Senator Slama, you're yielded 2 minutes and 27 seconds.
Thank you very much, Senators Conrad, Blood, and Brewer, for that really helpful exchange. I am really grateful to everyone who's still plugged in and being thoughtful about their approach to this. So I do appreciate, although we're on opposite sides of this, Senator Conrad, Senator Brewer, and Senator Blood's perspective, because we are a body of 49, and I'm grateful for their perspectives on this. Before I get into Bush v. Gore, which I know everybody's super overwhelmed and excited to get to, as Senator Conrad knows, it's an extremely long opinion. Extremely long, and I'm trying to find a court-approved syllabus on it so I don't have to go through the whole thing. But as I do that, I'm going to hop into some very helpful NCSL articles on voter ID laws so that you can understand where we took our concepts from, where we took from our sister states and our neighboring states, our ideas to craft my own amendment, and where I think the lessons learned by neighboring states could be very useful in how we move forward handling the Evnen Amendment. And again, I'm not hiding the ball here. I'm trying to be very transparent and precise that if the speaker or the chair of the government committee gets up and says, we're going to work with you on your constitutional concerns between general and select, I'm totally game for that. Like, I will sit down with a smile on my face, because I've taken the time to very clearly outline my issues with this bill and what I think we should be doing to alleviate those concerns. All I need is somebody to get up and say, you know what, you have our word that we'll work with you on these. We might not come to something that we can agree with, but I'll happily sit down if that just happens. And the fact that it hasn't happened yet pretty well outlines where negotiations on this have been like. So my first NCSL article on voter ID laws is aptly named Voter ID Laws, and it's from the 18th of October, 2022. There's a helpful note at the beginning. Please note, our organization does not run elections and cannot provide legal advice. If you are a voter looking for assistance, please contact your local election official. You can find your local election official's website and contact information by using this database from the U.S. Vote Foundation. Introduction.
Time, Senator.
Thank you, Madam President.
Thank you, Senator Slama. Senator Conrad, you're recognized.
Did I hit my 3 times? Oh, okay, there's my mic. Sorry. Sorry. Thank you, Madam President. Thank you, colleagues. Wanted to give Senator Slama perhaps a chance to find that synopsis that would save her and the transcribers probably a great deal of trouble instead of reading a very, very lengthy Supreme Court decision into the record. But I don't know if well, SCOTUS blog was probably around back then. That might be as good a source as any to check on, but I'm sure that there's probably some good rundowns that we could take a look at so that she could fully illustrate her point in regards to that measure, and as she sees fit in regards to this specific question before us. So I wanted to just run through a little bit of additional information in terms of some of the key components, some of the essential elements of the government committee's amendment, and how we kind of looked at some of the most important things to keep in mind when it came to carrying out the will of the people. And as some of you may know, there is a provision in our state constitution that essentially indicates that constitutional amendments, initiatives are self-executing. But this specific measure that Senator Slama and the other members of the campaign committee brought forward to the voters and was approved by the voters had a specific direction that the measure would be carried out as the legislature saw fit. And I definitely don't want to speak for Senator Slama and those that drafted the constitutional amendment that the voters approved, but I'm guessing that perhaps that deference or direction to the legislature for implementation and facilitation was probably made with an eye towards running afoul of a single subject prohibition in our powers of initiative or referenda or initiative or in terms of legislation as well. So I'm guessing that perhaps that's why there was a specific direction to the legislature for implementation. But again, I don't want to put words in their mouth or make assumptions. Nevertheless, what we do have before us in terms of the record is the record. And the key components of the legislative history on the constitutional amendment ballot initiative are a couple of very brief items, actually. We have the object clause that is put before voters at the time of signature. We have the ballot title that the Attorney General takes up in preparing the ballots for the voters after the signature gathering and verification process. And then we have the language itself. And then finally, we have a public hearing component that provides some additional education and information for voters and stakeholders. And then we have a voter information pamphlet where both the proponent and opponent campaigns are allowed to provide a brief explanation of their measure to the voters. So when you look at the text of the amendment, when you look at the ballot title, when you look at the object clause, when you look at the voter information pamphlet, you will see that there is no indication, there is no appearance of some of the issues that Senator Slama is most concerned about in regards to the committee's approach to implementation. So the committee focused on defining what a appropriate form, thank you, Madam President, of identification would be before casting a vote. We talked about the duties to the Secretary of States and election commissioners to ensure that there is a robust public awareness campaign so that eligible voters do not run afoul of the new requirements. We talked about how this would be implemented in terms of different groups of voters, folks who vote in person on election day, in-person early voters, and then folks who vote by mail. And folks who vote by mail, of course, have a variety of important subsets that we've already talked about in terms of, for example, overseas and military voters as well. So we tried to work through these different components to facilitate the will of the voters, following existing law as we understand it and good models from other states. So,
Time, Senator.
Thank you, Madam President.
Seeing no one else in the queue, Senator Slama, you're recognized to close on your amendment.
Thank you, Madam President. And I was able to find the syllabus of Bush v. Gore, a good syllabus. And in a bunch of my printed opinions, I didn't have a syllabus. My wonderful legislative aide, Tori Osborne, found it and so graciously got it to me. So I'm going to hop in now to the syllabus just so we have that on the record of Bush v. Gore. And if we want, we can expand on Bush v. Gore. Like, we've got plenty of time to come back to it, but I do just want to get the syllabus on the record to start. On December 8th, 2000, the Florida Supreme Court ordered inter alia, that manual recounts of ballots for the recent presidential election were required in all Florida counties where so-called undervotes had not been subject to manual tabulation, and that the manual recount should begin at once. Noting the closeness of the election, the court explained that on the record before it, there could be no question that there were uncounted legal votes, i.e. those in which there was a clear indication of the voter's intent sufficient to place the results of the election in doubt. Petitioners, the Republican candidates for president and vice president, who had been certified as winners in Florida, filed an emergency application for a stay of this mandate. On December 9th, this court granted the stay application and treated it as a petition for a writ of cert and granted cert. Held because it is evident that any recount seeking to meet 3 U.S.C. Section 5 December 12th safe harbor date would be unconstitutional under the Equal Protection Clause, the Florida Supreme Court's judgment ordering manual recounts is reversed. The clause's requirements apply to the manner in which the voting franchise is exercised. Having once granted the right to vote on equal terms, Florida may not, by later arbitrary and disparate treatment, value one person's vote over that of another. The recount mechanisms implemented in response to the state court's decision do not satisfy the minimum requirement for non-arbitrary treatment of voters. The record shows that the standards for accepting or rejecting contested ballots might vary not only from county to county, but indeed within a single county from one recount team to another. In addition, the recounts in 3 counties were not limited to so-called undervotes, but extended to all of the ballots. Furthermore, the actual process by which the votes were to be counted raises further concerns because the court's order did not specify who would recount the ballots. Whereas here, a court orders a statewide remedy, there must be at least some assurance that the rudimentary requirements of equal treatment and fundamental fairness are satisfied. The state has not shown that its procedures include the necessary safeguards. Upon due consideration of the difficulties intended to this point, it is obvious that the recount cannot be conducted in compliance with the requirements of equal protection and due process without substantial additional work. The court below has said that the legislature intended the state's electors to participate fully in the federal electoral process as provided in 3 U.S.C. Section 5, which requires that any controversy or contest that is designed to lead to a conclusive selection of electors be completed by December 12th. That date is here, but there is no recount procedure in place under the state court's order that comports with minimal constitutional standards. The case is reversed and remanded. And my takeaway here, and my takeaway that has been from the start, is that you can't apply different standards to different counties. I really do like the line referencing here that you might not even be creating different standards in a single county. You might be creating different standards within individual counties. Now, this is like when you ask thank you, Madam President, you ask your mom or dad something as a kid, and it kind of depends on the time of day in which you ask it as to whether or not you get it. So a county election clerk on election day, if you reach out at 9 a.m., might be very, very committed to their own structure of what a reasonable impediment should look like. And if you come in with a cold, the county election clerk might not believe that is a reasonable impediment and outright rejects you. However, when you've got 17 reasonable impediment requests stacked up, you're either going to delegate that task of deciding who has a reasonable impediment and who does not to somebody else, or you're going to, because it's human nature take different approaches to different concepts unless you have a clear set of standards laid out. If we're leaving this to just a subjective assessment by a single official or even multiple officials, we're lining ourselves up for a Bush v. Gore problem. And I understand.
Time, Senator.
Thank you, Madam President, and I withdraw that motion amendment.
Thank you, Senator Slama. Mr. Clerk, for a motion or a next item.
Madam President, Senator Slama would move to amend with FA 144.
Senator Slama, you're recognized to open on your amendment.
Thank you, Mr. President, and good evening again, colleagues. This is a key difference in Senator Conrad and I's assessment of the relevance of Bush v. Gore here, in that she, as I understand it, and she can hop in and correct me if she wants, I'm actually doing good on time, I'm good to go for a while, that the scope of Bush v. Gore is limited only to counting votes in different counties, in that leads to you essentially valuing votes in a greater way than another. I'm reading it a bit more broadly and saying that counties establishing different standards, in this case for voter ID, especially with the reasonable impediment language, would be running afoul of this decision. So for me, the main takeaway in Bush v. Gore is that. And I believe our reasonable impediment language either falls flat on the language of the state constitutional amendment, in which any voter can say they have a reasonable impediment and it's good enough, there is no checking, or we're leaving this to a subjective standard determined by who your county election official is, because there's not a standard broken down in statute for them to follow. Now with that, I do want to hop back into the NCSL articles on the voter ID laws. I'll start with the first one that I had up, which was October 18, 2022. And you can follow along with these online. The NCSL has a lot of really useful materials when it comes to voter ID. And I really want to hit on two articles right now. One, their main voter ID article, and then another one, which is how states verify voted absentee/mail ballots. Because right now we don't have that verification in our system, but the NCSL has a great toolkit and summary of how other states do it and how they appropriately do it, normally with a witness attestation or a notary or some combination of the two. So first up is the NCSL's voter ID laws main article, introduction. A total of 35 states have laws requesting or requiring voters to show some form of identification at the polls. Scroll over the map to see below for state-by-state details. Note, on April 1st, 2022, the Arkansas Supreme Court granted an emergency stay in the lawsuit against Act 249, which passed in 2021 and made changes to the Arkansas voter ID law, allowing the law to go into effect. The case is pending before the state Supreme Court. The remaining 15 states and DC use other methods to verify the identity of voters. More frequently, other identifying information is provided at the polling place, such as a signature is checked against information on file. See NCSL's voter verification without ID documents. And I'm going to include these references as I'm reading along, just because it is helpful to know like what's available in this NCSL toolkit. There are plenty of tools available if you just happen to be excited about voter ID and want to read more about it. And if you are, please talk to Senator Conrad and I. We have a fan club going and it's pretty lonely. Proponents see increasing requirements for identification as a way to prevent in-person voter impersonation and increase public confidence in the election process. Opponents say that there is little fraud of this kind, and the burden on voters unduly restricts the right to vote and imposes unnecessary costs and administrative burdens on election administrators. See state by state, in effect, voter ID requirements, Table 2, far below, for citations and details on what IDs are accepted and what happens when a voter does not have ID. Variations in voter identification laws. Voter ID laws can be categorized in two ways. First, the laws can be sorted by whether the state asks for a photo ID or whether it accepts IDs without a photo as well. Second, the laws can be divided by what actions are available for voters who do not have ID. These two categorization schemes can and do overlap. Photo versus non-photo identification. Some states request or require voters to show an identification document that has a photo on it, such as driver's license, state-issued identification card, military ID, tribal ID, and many other forms of ID. Other states accept non-photo identification, such as a bank statement with name and address or other document that does not necessarily have a photo. Using this categorization for laws that are in effect as of October 2022, so this one includes the state of Nebraska, 18 states ask for a photo ID, and 17 states also accept non-photo IDs. Procedures for when a voter does not have identification. If a voter fails to show the ID that is asked for by law, states provide alternatives. These laws fit into two categories, non-strict and strict. Non-strict, at least some voters without acceptable identification have an option to cast a ballot that will be counted without further action on the part of the voter. For instance, a voter may sign an affidavit of identity, or poll workers may be permitted to vouch for the voter. In some of the non-strict states, like Colorado, Florida, Montana, Oklahoma, Rhode Island, Utah, and Vermont, voters who do not show required identification may vote on a provisional ballot. After the close of Election Day, election officials will determine via signature check or other verification whether the voter was eligible and registered, and therefore whether the provisional ballot should be counted. No action on the part of the voter is required. In New Hampshire, election officials will send a letter to anyone who signed a challenge voter affidavit because they did not show an ID, and these voters must return the mailing confirming that they are indeed in residence as indicated on the affidavit. Now, the other segment we have for voter ID laws are strict. Voters without acceptable identification must vote on a provisional ballot and must take additional steps after Election Day to be counted. For instance, the voter may be required to return to an election office within a few days after the election and present an acceptable ID to have the provisional ballot counted. If the voter does not come back to show ID, the provisional ballot is not counted. So strict photo ID states include Arkansas, Georgia, Indiana, Kansas, Mississippi, Missouri, Tennessee, Wisconsin, Arizona, North Dakota, Ohio, and Wyoming. And there are some who would say Alabama's law is a strict photo identification law because voters who don't show a photo ID will generally be asked to cast a provisional ballot and then must bring their required ID to an election office by 5 p.m. on Friday after Election Day. However, there is an alternative. 2 election officials can sign sworn statements saying they know the voter. So it's a different variation of witness attestation, and it's not counted as strict because you don't necessarily have to show a photo ID in order to vote. So first-time voters, in addition to the laws governing what identification all voters must show at the polls, first-time voters may face additional requirements. The federal Help America Vote Act, so that's what is in your glossary listed as HAVA, Section 15483B2A mandates that all states require identification from first-time voters who register to vote by mail and have not provided verification of their identification at the time of registration. The Act lists a current and valid photo identification or a copy of a current utility bill, bank statement, government check, paycheck, or other government document that shows the name and the address of the voter as acceptable forms of voter ID. Now, there are some exceptions to voter identification requirements. Most states with strict voter identification requirements make some exceptions. So not all, and I can tell you right now, most of those that don't have exceptions are under some variation of court challenges. It's worth noting that both the Evnen Amendment and the Slama Amendment have exceptions. Have religious objections to being photographed. Indiana, Kansas, Mississippi, South Carolina, Tennessee, Texas, and Wisconsin have this. My own amendment has this, and the Evnen Amendment has a variation. Are indigent, that's Indiana and Tennessee, have a reasonable impediment to getting an ID. South Carolina uses this language, but again, it is different. Thank you, Mr. President. It is very different from Nebraska's approach, and South Carolina has very unique language compared to ours. Do not have an ID as a result of a recent natural disaster, Texas, and to call Texas strict voter ID is very generous. If you look more into the framework, you'll see a lot of workarounds for their framework. people who are victims of domestic abuse, sexual assault, or stalking and have a confidential listing. So that's in Wisconsin. And Senator Blood referenced that issue. And I think it's something Senator Brewer and I are both aware of and willing to work with. Anyone who might have an interest on that front, I consider that similar to the nursing home IDs exception of we're more than willing to work with anybody who comes to the table. Additionally, voter ID requirements generally apply to in-person voting, not to absentee ballots or mailed ballots. All voters, regardless of the verification required by the states, are subject to perjury charges if they vote under
Senator.
false pretenses. Thank you, Mr. President.
Senator Clement, you're recognized to speak.
Thank you, Mr. President. I will be making a few comments, then I have a question for Senator Slama in a little bit. The ballot initiative, I got ballots and took them around to people to get signed, and it was very easy to get somebody to sign the voter ID petition. And I see that there's been some challenges that there were inappropriate circulators, but I was very careful to make sure that I read the language to the person before they signed and got the proper signatures. And it wasn't all that hard. I was amazed how fast I got dozens of signatures on the ballots. And I was not surprised at all of what a strong majority, supermajority almost, of Nebraskans voted for the voter ID bill. And I'm pleased that we have it, and we're coming up with the details now, and I'm hoping that we can make it workable. Would Senator Slama yield to a question?
Senator Slama, will you yield?
Yes.
Senator Slama, thank you. As I was circulating petitions, one of the comments I got was, well, I want to make sure an illegal resident is not voting. And I was wondering if there's a comparison between the committee amendment and your proposal on a non-citizen, how we make sure they're not voting.
Yes, there is. And I really do appreciate that question because it is a key difference between the Evnen Amendment and my own and the citizenship checks. So right now, under the Evnen Amendment, the Secretary of State isn't required to do more than he already does, as outlined in the language that he just has to use the data accessible to him to conduct citizenship checks of voters as they register. This language aligns with the DMV's motor voter program, which covers about 55% of Nebraska voters. Meanwhile, my checks ensure that anybody who's using an ID that is used for voting purposes has opted into the citizenship check. So you get 100% coverage rather than just 55% coverage.
Very good. Well, thank you very much. I still think I'm generally in support of the Secretary of State's and his process, and I have not seen evidence of non-citizens voting, but I do encourage the committee and the Secretary to make sure that his procedures are only allowing citizens and people who should be voting and not allowing non-citizens to vote, because as I was getting those ballots, petitions circulated, that comment was made frequently. And I do charge the Secretary of State with being certain that we have only eligible voters that are voting at the polls. Thank you, Mr. President.
Senator Slama, you're recognized to speak.
Thank you, Mr. President. And I'm going to take a little bit of time to go through the next article. I could go a little bit more in detail for all the states that do have valid voter ID laws in place on that first article, but I do want to make sure that the second article in summary table 14, how states verify voted absentee/mail ballots, that is on the record, because there are a lot of states that do this in a way not unlike I'm approaching my own amendment, and in a way that verifies and ensures that our mail-in ballots are being secure. Bless you. I was just trying to find a pen to mark as I go. Summary table 14, how states verify voted absentee/mail ballots. This was an article by NCSL updated March 15th, 2022. The most common method to verify that absentee mail ballots come from the intended voter is to conduct signature verification. When voters return an absentee/mail ballot, they must sign an affidavit on the ballot envelope. When the ballot is returned to the election office, election officials have a process for examining each and every signature and comparing it to other documents in their files that contain the voter signature, usually the voter registration record. If a ballot is missing a signature or the signature does not match the one on file, some states offer voters the opportunity to cure their ballots. The election official will contact the voter explaining the problem and asking them to verify their information and that they did in fact cast the ballot. Some states have other methods for verifying absentee/mail ballots, such as requiring voters to provide a copy of their identification document or have the absentee/mail ballot witnessed or notarized. So this last one is the method we're taking in the Evnen Amendment. In the Slama Amendment, in the Evnen Amendment, it's a variation of the copied or ID number approach. So 27 states conduct signature verification on return/absentee mail ballots. Arizona, California, Colorado, Florida, Hawaii, Idaho, Illinois, Indiana, Iowa, Kentucky, Maine, Massachusetts, Michigan, Montana, Nevada, New Hampshire, New Jersey, New York, North Dakota, Ohio, Oregon, South Dakota, Tennessee, Texas, Utah, Washington, and West Virginia. The Virgin Islands and Washington, D.C. verify that an absentee mail ballot envelope has been signature verified as well. This cuts off, so I'm kind of confused as to where we go on the next side. But in any case, 9 states required the signature of a witness in addition to the voter's signature. These states may conduct signature verification or as well. So this is the witness attestation. This is the part of the language that I use in my own amendment to verify that a photo ID has been shown. These are the states that do solely witness attestation, so not using the notary option that I've added for the sake of our out-of-state voters. Alabama requires 2 witnesses or a notary. Alaska is a witness or a notary, so it's exactly the same as Nebraska's approach. Louisiana, Minnesota, which is again a witness or a notary. North Carolina, 2 witnesses or a notary. Rhode Island, which is 2 witnesses or a notary. South Carolina, Virginia, and Wisconsin. 3 states require the absentee/mail ballot envelope to be notarized. That's Mississippi, Missouri, and Oklahoma. Nebraska is in a very unique situation when we are comparing our language with the language from other states, in that our voters approved a constitutional amendment that automatically made us a strict photo ID, voter ID state. Thank you, Mr. President. So when we're talking about the majority of other states that have some form of voter ID, and we're talking about signature verification, that really doesn't play into anything that we can do in the state of Nebraska, because you do have that present an ID at the time of voting language that sets us apart from a lot of the other states. Arkansas requires a copy of the voter's ID to be returned with the absentee/mail ballot, and Georgia requires the voter's driver's license number or state identification card number, which is compared with the voter's registration record. So Georgia, based on this, is really the only one that I can see where we're leaning that hard on driver's license or state identification card number. And it differs from the Evnen approach in that you're using a far more expansive set of IDs with the Evnen approach, with no clear method of verifying that those license numbers are legitimate. And I will come back to this on my next turn on the mic. I'm probably up next.
Time, Senator. Senator Slama, you're recognized, and this is your last opportunity before your close.
Wild times. Thank you very much, Mr. President. And again, I'm willing to stand down. We could have saved 3.5, 4 hours if either the speaker or the chairman of the government committee would have simply gotten up on the mic and said, I'm more than willing to sit down and work with you and see if we can't come to a solution on the constitutional issues you've raised. Not a guarantee of an outcome, just a guarantee that we can discuss this. Like, this is choose your own adventure, and the leadership on this has chosen their own adventure. So we're going to talk a lot about what other states do, because I think that the Evnen Amendment fails to take into account lessons learned from other states in implementing voter ID in their states. So I was talking about Georgia, and Georgia's the only one in this list, as far as I can tell, that requires the voter's driver's license number or the state ID card number, which is then compared with the voter's registration record. Now, this is as close as I can see the Evnen approach getting to verification of mail-in voting. And the problem is that there's no real means of doing this under the Evnen Amendment because of how expansive the list of IDs you're talking about. You're talking about IDs issued by any political subdivision. There's no real requirement for the Secretary of State to have a list of what's a valid ID number and what's not, and what's requiring the Secretary of State's office to go number my number, type in the number, try to figure out if a number is a 7 or a 2, an 8 or a 3. I can see that creating a lot of extra work for the Secretary of State's office, and I think there's a very clear reason why only one state even takes close to that approach, and it's because there's not a really good parallel. And I think the Evnen Amendment is problematic because it does create an incentive not to follow through and verify those mail-in ballots. So Minnesota and Ohio also require this information. So the Georgia information of the ID number, though Minnesota also requires a witness signature and Ohio conducts a signature verification. So the Evnen Amendment language requires neither of those two things. So we are falling in line with the Georgia language, which is very liberal and doesn't really fit in with the language that our voters overwhelmingly approved in November 2022. So now we'll go through, and we could go through state by state with details on how absentee mail ballots are verified. But what I really want to do is go through the 12 states that require, oh, thank you very much, Joshua. Oh, that's so handy. Okay, my legal counsel just handed me the far better way of handling this. So I am going to go through the 12 states that require witness attestation or notary or some combination of the two, because it is important as we're going through this to understand why other states have taken this approach and that this approach works. I've had people bring up witness attestation and notary to me is some sort of foreign concept that how could we possibly do this in Nebraska? A lot of states and a lot of states with very rural populations are able to successfully do this. So it's important to note that we are not doing anything new with this approach. We're actually doing what's worked well in other states. So Alabama's our first state that requires witness attestation. You have to have either 2 witnesses older than 18 or a notary public to sign your return envelope. Absentee ballot return envelopes must be signed by the voter and either 2 witnesses or a notary public. If the witnessing of the signature and the information in the affidavit establish that the voter is entitled to vote by absentee ballot, then the election official shall certify the findings, open each affidavit envelope, and deposit, thank you, Mr. President, and deposit the plain envelope containing the absentee ballot into a sealed ballot box. I will come back to the other states while I try to find a pen so I can mark my way as I go. Thank you, Mr. President.
Did she withdraw? Seeing no one left in the queue, you are welcome to close on your floor amendment.
Ooh, happy to, and I just found my handy pink Sharpie, so I can mark as I go. All right, so the next state after Alabama that requires either a witness attestation or notary is Alaska, which I've heard a lot of. So Rhode Island requires 2 witness signatures for witness attestation, while Rhode Island's the size of like, you can fit 2 of them in Cherry County. Well, Alaska is a pretty expansive state as well, and they're able to do witness attestation. So an attesting signature is needed by a witness older than 18 or an official authorized to administer oaths. Absentee ballot return envelopes must be signed by the voter and a witness or other authorized official. Ballots are not counted if the voter or the official or witness authorized by law to attest the voter's certificate failed to properly sign the certificate on the outside of the return envelope. The next state up, I need to flip through a few here, is Louisiana. Louisiana requires the absentee ballot return envelope must be signed by a witness. Absentee ballot return envelopes bear a certificate and an affidavit which must be signed by a voter and a witness. The name on the certificate is compared with the names on the absentee by mail voter report. If a majority of members of the county board determine that an absentee ballot is invalid, the ballot is rejected or not counted. Minnesota, which I guess everybody knows is a super conservative stronghold when it comes to just about everything. I mean that as facetiously as possible. Minnesota has witness attestation. The absentee ballot envelope must be signed by either a witness who is registered to vote in Minnesota or by an individual authorized to administer oaths. A certificate of eligibility to vote by absentee is printed on the back of the return envelope and must be signed by the voter and a witness. Voters must also provide a Minnesota driver's license number, state identification number, or the last 4 digits of the voter's social security number. Election judges from different political party affiliations examine absentee ballots. If the voter's driver's license number, state identification number, or the last 4 digits of the voter's social security number on the ballot does not match the information provided on the absentee ballot application, the election judges must compare the signature on the ballot and application. Ballots that fail to meet the requirements, signature, eligibility, etc., are rejected. I'm going to take a back up here and note that Minnesota verifies every single one of these signatures when it comes to witness attestation. We, in Nebraska, with my amendment, are just doing an audit on the back end. We're auditing a statistically significant number of ballots. In this case, and from our research, like a statistically significant number of ballots would normally be around 1,000, and that's where you're going to get to the point of diminishing returns on actually finding fraud. We go through 1,000 through the Attorney General's office, and if there is evidence of extensive fraud, we go from there and expand out the search. Here in Minnesota, they're matching up every signature. Now, I've been told by the Secretary of State's office that this is somehow impossible and that we'll never be able to do it and that we don't know how other states do it, but Minnesota does it. Like, Minnesota is not a really conservative bastion here, and they have a common sense election security measure in place, and Nebraska's taken in the Slama Amendment an even more thoughtful approach that minimizes the work on our election workers and takes a very thoughtful approach to election fraud and finding election fraud. The next state,
1 minute.
Thank you, Mr. President, with the witness attestation language is North Carolina, which it is worth noting that North Carolina's language was recently upheld by their state court, so that is in force. We can't put an asterisk next to North Carolina and say their laws aren't in place. Absentee ballot envelopes must be signed by 2 witnesses who are at least 18 years old or a notary public. The absentee ballot contains a certificate that the voter must sign. The certificate must be witnessed by 2 persons at least 18 years old or by a notary public. The 2 witnesses must also indicate their addresses. So I'll come back to describing what other states do, because it's so important we know what other states have done and knowing that we're not reinventing the wheel here. And with that, I will withdraw my floor amendment.
So ordered. Mr. Clerk, next item.
Mr. President, Senator Slama would move to amend with FA 147.
Senator Slama, you are welcome to open on FA 147.
Outstanding. Thank you very much, Mr. President. I appreciate the opportunity to continue this riveting speech on what other states do when it comes to witness attestation and notarization. because we need to have a legislative record of what other states have done and what other states have done successfully, because the Evident Amendment clearly breaks from the best practices established by our sister states. And my own amendment takes those lessons that we've learned through innumerable court cases, innumerable other states' laws and proposals, and goes forward with a successful framework that ensures that whether you vote by mail-in or in person, that you're fulfilling the language of our constitutional amendment approved by voters by a 65-35 margin, and that you are showing a photo ID in order to prove that you are who you say you are in order to vote. It is as simple as that. So we just talked about North Carolina when it comes to witness attestation. The next one up is Rhode Island. Rhode Island's unique in that an absentee ballot envelope must be signed by 2 witnesses or a notary public. Military and overseas voters do not need a signature or a notary. Mail ballot envelopes are printed with a certificate that must be signed by the voter and a notary or 2 witnesses. Election officials compare the name, residence, and signature on the certificate with the signature on the absentee ballot application to ensure they are identical. Ballots that can be reasonably identified to come from the correct eligible voter are certified. Next up is South Carolina. Absentee ballot envelopes must be signed by the voter and a witness. Military and overseas voters are exempt from the witness requirement. Absentee ballots must be returned with an oath that is signed by the voter and a witness. No ballot is counted unless the oath is properly signed. Virginia also uses witness attestation. Absentee envelopes must be signed by a voter and a witness. The return envelope is printed with a statement that must be signed by the voter and 1 witness. If the affirmation on the envelope is completed as required, the ballot is counted. And the final one, and I believe the original state that first started using witness attestation when they passed their voter ID law in 2013 is Wisconsin. In Wisconsin, their law is that absentee ballots must be signed by the voter and a witness. The absentee ballot includes a certificate that must be signed by the voter and witnessed. If the certificate is insufficient, the ballot is rejected. And there are 3 states that require absentee mail ballot envelopes to be notarized. They're a strict notary state. We did not go that route. The white copy amendment of LB 535 originally had that language. We decided to go another route after hearing the thoughts of the feedback from the committee hearing. The first strict notary state is Mississippi. In Mississippi, absentee ballot envelopes must be signed by a notary public or other official authorized to administer oaths. The absentee ballot envelope contains a certificate that must be signed by the voter and an attesting witness who is authorized to administer oaths. Absentee ballots are not counted if the envelope is not signed by the voter and an attesting witness. Election officials compare the signature on the ballot envelope with that on the absentee ballot application. If the signatures match, the ballot is counted. If the signatures do not match, the ballot is rejected. Next one up with a strict notary statute is Missouri. And Missouri was actually the state in which we pulled a lot of our notes from the white copy amendment to LB 535 with the strict notary framework. Absentee ballot envelopes must be signed by a notary election official or other officer authorized to administer oaths. Absentee ballot return envelopes are printed with a statement that must be signed by the voter under penalty of perjury. The affidavit of each person voting an absentee ballot shall be subscribed and sworn to by the election official receiving the ballot, a notary public, or other officer authorized to administer oaths. The ballot is rejected if the statement is not completed. Oklahoma is the final one. That is a strict notary state. It's one of 3. And it's our third one. Yes, absentee ballot envelopes must be notarized. Absentee ballot return envelopes are printed with an affidavit that the voter must sign. The affidavit must be witnessed by a notary. Notary publics must maintain a log of all absentee ballot affidavits that they witness and may not notarize more than 20 absentee ballot affidavits for a single election without the written approval of the election board. The county election board reviews each ballot to verify that the affidavit was properly executed and determines whether improperly executed affidavits should be accepted or rejected pursuant to law. So Oklahoma's language is actually incredibly interesting, and it's unique in the sense that not only do you have the notary requirement, you also have a limit, and I do appreciate this concept to prevent bad actors and ballot harvesting, in that you have a limit of a notary public not being able to notarize more than 20 absentee ballot affidavits for a single election without the written approval of the election board. Because one of the most common objections we had to strict notarization is that Nebraska's a rural state. We don't have access to a lot of notaries. Aaron Sandiford with the Nebraska Examiner actually did a really interesting article on the dispersion of notaries in the state of Nebraska. And Oklahoma is a state with a lot of rural populations, very similar to Nebraska. And I do find it interesting that not only are they able to make it on a strict notary state, but they can also limit the number of attestations signed by a single notary and still function and run their government, run their elections well. So I've gone through and discussed the states that have witness attestation or notary or a combination of both, just to show that my approach isn't reinventing the wheel. It's a very common approach for states with strict voter ID laws who treat mail-in ballots as they do ordinary votes. And with our constitutional language, we are in a unique position in that our constitutional language did not specifically exempt mail-in voting. Therefore, that mail-in voting has to be covered by the photo ID requirement just as much as it is in person. So that puts us in a unique position where you do have to prove up, even if you're mailing in your ballot, that you have a valid ID and are eligible to vote. So I'm going to find something else to read. I do have more NCSL articles. I do have the full Bush v. Gore opinion, but what I think I might do on my next turn up is go through again my constitutional concerns with the Evnen Amendment, because we haven't touched on that for a while. And I do think it is helpful every so often to reground ourselves in my constitutional objections to this Evnen Amendment and really explain why I'm taking this much time on the mic, because I do think we are failing the will of the voters, and we are passing something that's very clearly unconstitutional and rejects the 65% of Nebraska voters who did vote in favor of a strict photo ID voter amendment, voter ID constitutional amendment. Thank you, Mr. President.
Senator Slama, you are next in the queue.
Outstanding. Well, I can very slowly go through my summary sheet and extemporaneously expand on that because I was unable to turn off my light and turn it on in time. The struggle is real. So I do have a number of issues with AM. It's originally 1748. I'm just referring to it as the Evnen Amendment. We adopted it earlier today. Section 5 violates the National Voter Registration Act by eliminating due process for a voter that's found to not properly be registered or on the voter rolls. Section 10 places an undue burden on the fundamental right to vote. We have a case law directly on point. It also violates the amendment passed by voters by allowing non-exempt persons to vote without showing a valid ID. Section 11 places an undue burden on the fundamental right to vote. Again, we have case law directly on point. It also violates the amendment passed by voters by allowing non-exempt persons to vote without showing a valid ID. Section 12 violates the fundamental right of a person with a religious objection as outlined by the United States Supreme Court. Section 17, you've got either two problems here, and I messed up in my reference in the Missouri case. It was referencing sections 17, 18, and 19, not sections 10 and 11. That's my fault for not having the individual sections of this memorized offhand. So we're running into either violating the fundamental right to vote We've got the Missouri law directly on point. We also violate the amendment passed by voters by allowing non-exempt persons to vote without showing a valid ID. Or we create an equal protection clause issue as articulated by the United States Supreme Court. Section 18, again, either violates the fundamental right to vote or it runs into a 14th Amendment Equal Protection Clause issue. Section 19 is the same thing. Section 23, when you take it with the rest of the bill, it violates the Privileges and Immunities Clause of the 14th Amendment in that you're creating a situation where you have two separate classes of citizens in the state of Nebraska. Class 1 is a person is born in the state of Nebraska and can get free assistance from the Secretary of State's office in procuring items like their birth certificate and other valid documents for free, or you fall outside of that and you were born outside of the state of Nebraska and you cannot get that assistance for free guaranteed by the Secretary of State. Like, that's a very clear cleanup problem that I think we should be at least willing to address. And no one, whether it be the speaker or the chairman of the government committee, have been willing to even get on the mic and say, will it work with you on the issues that you have between general and select. And here's the thing, is I played a leading role in getting Initiative 432 across the finish line to finally amend our Constitution to have a common sense voter ID law in place. And I'm not going to stand by while the will of the voters is trampled on. So that's why I'm taking this 8 hours. Medically, should I be doing this? Absolutely not. Like, my doctors are probably like taking blood pressure medication right now because I'm absolutely going against all doctor